cameras turned off, the campaign has died, but the work we started, it never subsided. From the desert floor to the mountain height, we're shining the torch, we're bringing the light. 17 counties under one big sky. We're watching the records, we're asking them why. Oh, W4Nevada, the people's own desk, putting the truth to the ultimate test. For the school boards, the cities, the local town hall, we're showing up, brother, we're answering the call. From the receipts to the findings, we lay it all down. Accountability in every Nevada town. If the shadows are growing and you need some sun, bring it to us, now the healing's begun. Speak plainly, speak loud, let the truth be heard. We're keeping our promise, we're keeping our word. W4Nevada.com, you know where to go. Call or text that number, let the power flow. 702-381-4295. Nevada for Nevadans, we're still alive. Power back to the people, power back to the people.
Get your skates ready, and or your rolling chair, whatever you got. Bam, 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 bam. Well, good afternoon, Nevada, and welcome back to W4Nevada Live. We are continuing our coverage, and here in Clark County District Court, Department 13, before the Honorable Judge Mark Denton. If you are joining us today, maybe you have watched pieces of this case, but maybe you've not been able to sit through it full 8 days, now into 9 days. I want you to see, before this court resumes, I want to bring everybody up to speed. So before this case is enormous. It involves water rights, state regulation, property rights, senior water users, endangered species, development approvals, and a claim loss reportedly exceeding $1 billion. But beneath all of that technical language, the central question and the actually pretty simple: did Nevada regulate Coyote Springs so heavily that it effectively took the economically viable use of its property? Or was Coyote Springs still moving through an unfinished administrative process where the state engineer had not yet made the final decisions necessary to determine who actually gets the water? That is the fight we have now watched develop for more than 8 days. And remember, this is a bench trial. There is no jury. Judge Denton is hearing all this evidence and ultimately has to separate the documents, testimony, legal arguments, and years of administrative history to determine what actually happened. So let's go back to the beginning. Coyote Springs was planned as a massive master plan community roughly 50 miles north of Las Vegas, spanning both Clark and Lincoln counties. We've heard both testimony about the development agreements, contemplating tens of thousands of homes, commercial development, recreation, roads, schools, utilities, water and wastewater infrastructure, golf, and what was envisioned as an entire community. Water was obviously essential to that. At the center of the project were groundwater permits traced back to permit 46777 and a larger portfolio of related rights that we have been calling the base permits. Coyote Springs says that those permits were treated as real development assets. They drilled wells, they built infrastructure, they negotiated with developers, they obtained development agreements, they spent enormous amounts of money. Nevada's position is that Nevada's water permit is never an unconditional guarantee that the permit holder gets to pump that water forever, regardless of what later science shows. Senior rights still matter. Beneficial use still matters. and the state engineer has a continuing obligation to administer Nevada's public water. Then the science became much more complicated. The groundwater beneath those separately numbered basins connected through the regional carbonate aquifer. And that matters because pumping in one place can potentially affect springs and river flows somewhere else. The Muddy River has senior decreed rights. The Moapa-Dace depends on springs inside of that system. So the state engineer ordered a major regional pump test under Order 1169. Now that test ran for more than 2 years. Afterwards came rulings 6254 and 6255. Those rulings said, among the other things, that the groundwater system was highly interconnected, that groundwater pumping affected springs feeding the Muddy River, and that additional pumping could create conflicts with senior rights. Nevada says that this was scientific reality catching up with earlier assumptions. Coyote Springs says physical connectivity does not automatically answer the legal question of whether Nevada could later combine separately administered basins and effectively strand existing permits. That distinction has followed us through this entire trial. And then we reach the document that CSI says changed everything. On May 16, 2018, then State Engineer Jason King issued a letter dealing with subdivision approvals. The essence of it was that he could not justify signing subdivision maps relying upon junior groundwater in this regional system unless another water supply could be identified. CSI says that was the moment the project was effectively stopped. Nevada says it was not a formal order, it did not cancel permits, it did not formally curtail pumping, and no specific subdivision map had yet reached the state engineer for final action. CSI says that distinction is meaningless in the real world. Their position is, if the government official who ultimately has to approve the water tells you he will not approve the water, you do not spend hundreds of millions of dollars pretending everything is fine. But then the May 2018 letter was formally rescinded. That happened in an August 2018 settlement. CSI agreed to participate in the state engineer's continuing administrative process in good faith. The state engineer agreed to continue processing matters, and this is where Nevada has built one of its strongest arguments. Thank you, Mr. Sylvester. After the settlement, the administrative process continued. There were continued public workshops, there were stakeholder meetings. CSI themselves participated, its engineers participated, its lawyers participated, its consultants participated, some of whom were former state engineers. Resource Concepts Inc. keeps coming up. And Nevada says that this is evidence that no final takings had occurred. CSI says participation does not mean that the project could actually move forward. We then saw the September 2018 subdivision approvals. Nevada has emphasized that maps were not simply ignored. They were processed and conditionally improved. One involved approximately 575 residential lots. But the conditions required CSI to establish sufficient and sustainable water and obtain the necessary GID, General Improvement District, or water service confirmation. CSI says those conditions created an impossible circle. The state engineer questioned the groundwater. Las Vegas Valley Water District, or LVVWD, would not certify the sufficient water because the state engineer questioned it. And without the water certification, the maps could not move forward. Nevada says that still was not a final denial of every possible development path. CSI says conditional approval means very little when the condition cannot be satisfied. Then came an interim order 1303. That's important because some earlier testimony initially blurred 1303 together with later numeric pumping limits. During cross-examination, Amelia Cargill corrected that Order 1303 itself did not contain the numeric pumping cap she initially associated with it, but it did establish a regional process and required a showing of adequate and sustainable water before certain development could proceed. CSI submitted technical work from Stetson Engineers. Steve Reich proposed an adaptive management framework. That framework acknowledged uncertainty. It acknowledged groundwater and surface water connection. It acknowledged risk to senior rights and the Moapa-Dace. But it also proposed monitoring, triggers, and adjustments, so development could potentially proceed while the science itself had continued. Nevada says CSI's own experts acknowledged that there was genuine scientific uncertainty. CSI says later their experts gave Nevada a path forward, and Nevada never meaningfully implemented it. Then came 2019's evidentiary hearing. This was not some informal meeting in a conference room. It was a substantial administrative hearing involving CSI, Southern Nevada Water Authority, Las Vegas Valley Water District, federal agencies, the Moapa Band of Paiutes, Moapa Valley Water District, Lincoln County Interest and Environment Organizations, and others. CSI presented experts. Other stakeholders presented experts. And we learned during this cross-examination that this process was not intended to resolve every individual concept or conflict. That is where the concept of Phase 1 and Phase 2 became critical. Nevada's position is essentially Phase 1 establishes the hydrologic facts. How big is this connected system? How much water can sustainably be pumped? And what is happening to the muddy river? Then Phase 2 deals with the actual management consequences. Which senior rights are valid? Which rights are being used? Which may have been forfeited and or abandoned? Who ultimately gets to pump? And how much? Nevada has now explicitly told Judge Denton that this goes to the ripeness issue. If that Phase 2 process never finished, Nevada asks how CSI can claim that the government reached a final decision permanently eliminating its water. Then Order 1309 or 1309 arrived in June 2020. And this is where the story becomes even more complicated. Order 1309 established major factual conclusions regarding the regional groundwater system. But Nevada has spent days demonstrating that Order 1309 did not itself say that CSI gets zero water. It did not identify exactly who could pump what amount, and it did not finally curtail every individual junior permit. And CSI's own later court filings became some of Nevada's strongest evidence on that point. In a 2023 judicial review filing, CSI itself argued that Order 1309 did not determine who gets that water or how much. CSI argued that those management decisions had not yet been made, and Amelia Cargill acknowledged during this cross-examination that this was a true statement at the time. The Nevada Supreme Court also described Order 1309 as establishing factual groundwork rather than imposing individual user curtailment. Nevada says, there is your unfinished process. CSI says, while everyone debated whether the process was technically unfinished, our homes still could not be built. And remember what happened only days after Order 1309 was that CSI's large lot map receives a negative water recommendation in June 2020. Cargill testified that between Order 1309 and that map decision, CSI understood that Nevada was not going to allow the project to proceed. Nevada then asked a very simple question. If the project was dead, why did you keep everything alive? Why did you keep filing extensions? Why preserve subdivision maps? Why move water between wells? Why participate in administrative proceedings? Why pursue outside water? Why buy senior rights? Why keep trying? And Cargill's answer has become one of the central distinctions in this case. Preserving rights is not the same as actively developing. She says CSI stopped starting major new infrastructure projects, closed out existing contracts, preserved permits, maintained the golf course, continued beneficial use, and did whatever was necessary to stop its assets from expiring. Nevada says CSI's own documents repeatedly say something stronger than preservation, and that brings us into day 8 and 9. We saw, give me one second, I didn't hit live on Instagram there. We saw CSI continuing to examine outside water strategies. Albert Sino Jr. wrote in 2021 about an alternative pipeline and said, quote, I can make this happen. CSI discussed obtaining water from the Muddy River and or from other sources, then evaluated the Tuffy Ranch water. They continued talking about bringing outside water to the Coyote Springs. Then came another major development. CSI attempted to purchase approximately 2,300 acre-feet of senior rights from the then Church of Jesus Christ of Latter-day Saints, the LDS Church. Stated the purpose in CSI's correspondence was to use the senior rights to support the subdivision maps and begin building homes at Coyote Springs. When questioning reached confidential pricing information, the public feed was actually removed yesterday during that portion of testimony. And later when Nevada began questioning Cargill about agreements between Coyote Springs and estuary, confidentiality again became an issue, and they cut the feed. The estuary subject is becoming increasingly important because it involves renewable energy opportunities that have been happening in Lincoln County. And today, day 9, Nevada has pushed the documentary even harder. This morning, we went through years of water permit extensions. Those documents show CSI telling the state engineer that millions of dollars were spent developing the wells and water infrastructure. They also repeatedly told the state engineer that these rights were connected to a massive Clark and Lincoln County master plan development. But Nevada established something important. Those permit filings generally did not contain the entire amount that CSI now says it spent developing the master plan. The broader CSI damage summaries reach well into the hundreds of millions of dollars in claimed investment and expenses. So Nevada is asking how much of that broader financial exposure the state engineer actually knew about through those specific permit filings. Then the state confronted CSI with its own words. A September 2020 filing told the state engineer CSI intends to continue pursuing its development plans in the Coyote Springs Valley. A 2021 filing said it again, and another document said CSI wanted to proceed with the master plan but had been halted by the state's actions. Those statements may summarize the entire case better than anything else we have heard. CSI says, "We intended to build," and in the same breath, "We could not build because Nevada has stopped us." Then before lunch today, the damages picture changed again. Nevada introduced CSI's 2022 testimony before the Board of Equalization, where Cargill was arguing for a reduced property valuation because the project could not currently be proceeding. But she also testified before 1309 CSI believed that the property could be worth closer to $300 million, particularly with its water rights. And she described Albert Sino as someone who still believed he would eventually develop the property. Her point at the tax proceeding was the property was still alive, we still believe in it, but right now we cannot develop it. The future value versus present use distinction may become extremely important. And then we reach Lincoln County and Estuary. Nevada established that CSI has continued pursuing renewable energy opportunities in the Lincoln County portion of the Coyote Springs. Lincoln County Development Agreement was amended to accommodate substantial renewable energy. Estuary was already in discussions with CSI by 2023 period, and Cargill confirmed something very important today. The operative takings claim before Judge Denton is now focused on the Clark County property. An earlier pleading had alleged that the taking of a broader Clark and Lincoln County Coyote Springs property. The later operative complaint narrowed that. So from the point forward, we need to keep these properties separate. Lincoln County may have renewable energy value. Clark County is where the residential water-dependent takings claim is now focused. Those are not necessarily the same economic question. So where we are right now is we go from day 9. Nevada is building a case that says the state engineer never finally decided that CSI gets no water. The administrative process remained unfinished. CSI kept pursuing permits, kept pursuing development possibilities, sought outside waters, sought senior waters, pursued other economic opportunities. Itself told courts and agencies that management decisions had not yet been made. And CSI's answer is, you can keep a permit alive on paper forever. You can keep filing documents forever, you can keep fighting forever, but if the government will not sign the map, the homes do not get built. And needing to find replacement water may not prove the original water remained unusable or usable. It may prove exactly the opposite. That is the case that Judge Denton today is being asked to decide. Did government regulation finally cross the line into compensable taking? Or are we looking at a developer whose project remains caught inside a difficult but still unfinished Nevada water rights process? And after more than 8 days, now 9, of testimony, that question is not getting simpler. It's getting more precise. We are back this afternoon, right now. And we'll get our notes ready. Thank you so much for tuning in. I appreciate each and every one of you that takes the time to do that. And I'll silence myself so you can hear them. Thank you.
Is now in session.
Good afternoon, please be seated. We're back on the record. Witnesses retaking the stand. You may resume.
Thank you, Your Honor. Brandon, please bring up admitted exhibit 4016, please. Your Honor, this was a document that was submitted conditionally. Mr. Hudson wanted the opportunity to go back and review our pretrial stipulation with respect to how to introduce documents that weren't either part of a pretrial disclosure or otherwise placed into the evidence vault. I believe Mr. Hudson has had a chance to review that stipulation and agrees with our interpretation that that document may be properly admitted.
Yeah, we did go back and take a look at the document, took a look at our stipulation, and counsel has proceeded correctly, and we have no objection to this exhibit 4016 being admitted.
All right, so ordered and submitted.
Brandon, may I have state proposed exhibit 3531, please? And just tell me briefly, Ms. Cargill, if you recognize that document.
This is a letter dated November 30th, 2016 that I sent to Commissioner Marilyn Kirkpatrick.
And the second paragraph, I'll read it for you, states, as you know, of the 44,000 acre master plan community of Coyote Springs, 6,881 developable acres in Clark County, Nevada. There are 21,454 developable acres in Lincoln County, Nevada, with the balance of the property in both counties as set aside as conservation property. And then you attach a drawing. If I can go to the next page of that document, Brendan. Can you describe for the court this map?
This is a depiction, it's what I call a plat that shows all of the property owned by Coyote Spring Investment, Coyote Spring, Nevada, or Coyote Springs Nursery LLC in the Coyote Spring Valley. And it shows both the fee-owned land and the conservation area. And this is done, I'd have to see the date on it when it was created, but this was created by one of my employees.
Okay. And offer a state's proposed exhibit 3531.
No objection.
Admitted.
May I have state's proposed exhibit 3769, please? And tell me, Ms. Cargill, if you recognize this document dated November 10th, 2021.
This is a letter that Mr. Sino sent to Mr. Oric, the then president of Howard Hughes Corporation, Summerlin.
And had you seen this document before?
Yes, I have.
Okay, now just can we agree that it's after the entry 1309 or the ruling 1309 was entered?
Yes, it is.
Okay. And is it, I think that 1309 is June of 2020. Does that comport with your recollection? I'm happy to show you the document.
1309 was June of 2020. I agree.
And then shortly thereafter, there was the denial by Mr. Shell following the ruling 1309, just to orient you in time.
Yes, I would agree.
And do you know for what purpose this document was penned by Albert Sino Jr. to the Howard Hughes Corporation?
Someone that we were, I think he still had his position then. A gentleman who was the head of US Bank Nevada, who was on our US Bank account, told Mr. Sino, he and Mr. Sino were chatting, and he told Mr. Sino he knows Mr. Oric and asked if he could make an introduction for Mr. Sino to Mr. Oric. And so that gentleman made that introduction and gave Mr. Sino Mr. Oric's email address, and Mr. Sino sent this letter, and then later went and met with Mr. Oric, and they had I was not present, a brief conversation. And
I don't want you to tell you what that conversation will ask Mr. Howard Sino Jr. if you're just going to relay something somebody else told you. I don't mean to
yes, I
interrupt.
was not there.
Okay, can you read into the record at least the last full paragraph on page 001, please?
Coyote Springs is 43,000 acres of fully entitled developable fee land and designated conservation land. Habitat conservation and environmental permits issued and active. Over 4,000 acre feet of deep carbonate aquifer water we own, which is permitted for use in Coyote Springs Master Plan community. And opportunities to build a water line to bring additional water. We have 40-year development agreements in both Clark and Lincoln counties with entitlements to build 49,600 residential units in Clark County and 110 in Lincoln County. I completed fully functional water treatment plan and wastewater treatment plants at Coyote Springs with enough capacity to build thousands of homes. I also completed the required 2-mile storm control, flood control, retention basin, which is a part of the Clark County Regional Flood Control Master Plan. These facilities were built to Clark County and Las Vegas Valley Water District standards.
When Mr. Sino Jr., if you know, was providing an opportunity to Howard Hughes, did you have some understanding as to what that opportunity was?
No, does he use that phraseology in this letter?
He does in the second paragraph. It says, I'm
I
writing.
I can't see that.
Sure. Second paragraph, Brendan. I'm writing to introduce you to an opportunity in your backyard that would take your division of the Howard Hughes Corporation and Southern Nevada into the next century. And then he says Coyote Springs. Do you have some understanding as to what that opportunity reference was?
I don't know. Other than what the actual words on this page say, as I said, I was not present at the meeting. I don't know what he presented to Mr. Orick.
And when he references in the last full paragraph that you had read into the record, the opportunities to build a water line to bring additional water, do you know to what he was referring, what he advised Mr. Orick as the president of Howard Hughes Corporation? I
Do not know. I also don't know that I drafted this letter. I have no recollection that I drafted it. I don't know necessarily specifically what he is referring to there.
Okay. Thank you, Brendan. If you bring that down and bring up Brendan, if you would. I'm sorry.
No objection, Your Honor. 3769. 3769.
3769. All right. Brendan, can you return to state's admitted exhibit 3367? And we've looked at this before, Ms. Cargo, it's that exhibit to one of the amendments to the party agreement, and we spent some time talking about the allocation of costs and expenses. I just want to ask you some questions as we go through this document. As it relates to the first category of documents, as we go through it, I'm going to ask you whether the state engineer had required of any of these proposed improvements, either verbally or in writing, to the best of your recollection, okay?
As of July of 2006.
As of any date in your mind where you would say in response, let's take the first one, the water treatment plant. That's an obligation that party has. I'm sorry, 0014, Brendan. Okay. So this is the top category, is the improvements that CSI has to make and what party has to make an allocation of those expenses. And so as we go through the first category, I want you to tell me at any point on the continuum where the state engineer required or directed CSI and or party to complete these improvements as they're identified. Okay. With me on the scope of what we're going to be doing?
I think so.
Okay. As it relates to the water treatment fund, did the state engineer require that a water treatment plant be constructed?
I've never heard the state engineer say to me that we had to do so.
Have you ever seen a writing to that effect, to your knowledge, to CSI or somebody associated with CSI or Part D?
I don't know that I have, or I haven't seen a writing from the state engineer's office related to the water treatment plant.
The wastewater sewer distribution system have you seen a writing or any direction from the state engineer that Part E or CSI was required to construct those improvements?
I hesitate on that one only because we would need to distinguish the reclaimed water and the reclaimed water permits, and that the state engineer issues for reclaimed water, and then the filing of extensions of time and showing what work had been performed related to the reclaimed water.
I think, as I understand your testimony, correct me if I'm wrong, that relates to the water, the permitted water that could be utilized in the wastewater sewer distribution system. Would that be accurate?
On one end of the wastewater, on the treated side of the wastewater distribution system. And then I would also just say that I'm answering these questions very, very narrowly as to the Division of Water Resources, Mr. Sylvester, and not any other division that's underneath the parent division, so to say, of the Department of Natural Resources, because then that becomes a more complicated answer.
Did anybody, well, back up, the lawsuit is against the state engineer, right? As its relation to the state of Nevada?
It is, but I can't recall if the Division of Natural Resources was also a named party. I can't remember sitting right here right now.
Did the state engineer, to your knowledge, direct or instruct Party or CSI to construct a wastewater sewer distribution system?
The answer I just gave a moment ago, where I referred to the other than descriptions and related to the, oh my goodness,
Permit?
that's not the word I was looking for. The treated effluent permit that was received, and that's not the correct word, but that's the essence of what I'm saying.
Is that reuse?
Thank you, the reuse water permit, yes.
And that's the permits to use the water within the, whatever the wastewater sewer distribution system in, or wastewater treatment plant. Was that accurate?
It's the distribution system that follows after the wastewater treatment plant, yes.
State engineer required Party to build a distribution, Party or CSI to build a distribution system, or is that just a system that's necessary to allow you to recycle and use the water?
In order to use the reuse water, a distribution system would have to be constructed.
Okay. How about the power substation? Is that something that state engineer was requiring CSI to construct, or Party?
I don't believe so.
Okay. How about the on-site regional drainage? Is that something that the state engineer required to be constructed, or was it by the Clark County Regional Flood Control District? If you know.
I'm pausing on that one. I'm not entirely certain. Of course, Clark County Regional Flood Control would be involved, but because of the interaction related to the dam safety permits and the dam safety storage requirements in the state of Nevada, which are overseen by the dam safety division within the state engineer's office, I'm not entirely certain, Mr. Sylvester, on that one, where those lines of requirement cross.
Okay, we go to the next category. There is something that you have referred to as the off-site detention basin. Is that what you were referring to a moment ago?
The off-site detention basin is a part of the, it is the on-site, whatever it's gone from my screen now, but whatever the on-site drainage is, ties into and connects with the off-site detention basins. And that's what I was saying. I'm not certain where those lines of demarcation between Clark County Regional Flood Control and the Dam Safety Division within the state engineer's office cross.
Offsite power improvements, is that something the state engineer required party or CSI to conduct?
I don't believe so.
Gas line extensions, is that something that the state engineer required CSI or party to complete?
Again, I don't believe so.
Go to the next category. This appears to relate to environmental permits and the Lincoln County Power Corridor. Would you agree that the state engineer didn't require CSI to expend or party to expend any monies in pursuit of those permits?
Which permits are you referring
All of them
to?
listed in that subcategory.
Perhaps the all environmental mitigation, the state engineer may have required certain environmental mitigation related to the permits, since as we've seen in some of the permits, there are environmental, and falling into that category of environmental mitigation would be included Moapidase and other desert tortoise. There probably are some crossovers there just by virtue of complying with the permits.
Okay, that would require you to comply with, for instance, we've talked about many times, not using the permitted water to the extent that it impacted the endangered species known as the Moapidase, right?
That could be a part of it, yes, and that same answer would apply to the environmental permitting costs. That's the first bullet point there.
It may, but sitting here today, you don't know one way or the other.
It's a real broad category, Mr. Sylvester. I mean, all of these 5 bullet points are really broad categories. So environmental permitting costs and environmental mitigation, because of the reason for these categories had to do with cost share, it's possible that there is some cost that I can't say that those are excluded, rather.
The next subcategory talks about the wastewater treatment plant.
I don't see that.
It's on 0015.
Okay,
Is it your testimony that state engineer directed CSI and or party to construct a wastewater treatment plant?
I don't know that I've ever seen anything wherein the state engineer required. Could there have been discussions about it or correspondence about it, or could it have been a part of plans? That I am not certain of sitting here right now.
Okay. Brittany, can I have plaintiff's trial exhibit 25, please? Ms. Cargill, this is a document style application for extension of beneficial use. And it's the owner of record is the Coyote Springs Reuse Water Company. Signed by Mr. Savely on December 10th. I'm sorry, December 30th, 2010. Do you recognize the document?
May we go back up to the top of the? I don't know that this is to put this to beneficial use. I think this, can we go down a little bit farther? This may be to file a proof of, yes, see in number 6. This is to file the proof of completion of work.
Okay. And it is relating to permit number 77340. Do you recall what that permit relates to?
That is one of the Coyote Springs Reuse Water Company permits for reclaimed or reuse water that comes out of the wastewater treatment plant.
Is Coyote Springs Reuse Water Company LLC still the owner of record of that permit?
To the best of my knowledge, yes.
To your knowledge, are they a plaintiff in this action? Just to the best of your knowledge.
I don't believe so.
At item 5, it says, what is the expenditure on the project under this permit? Last year, on the project under this permit, last year, it says $725,000. And then total to date is $27 million. Now, reflecting back on, and I'm happy to show it to you again, the jointly financed improvements, is this? If you bring that back up, Brendan, just for a moment, 33670014. Just so we can orient the court as to what we're talking about with respect to the improvements relating to this application. Do you know which one of those categories this relates, if any?
I believe that all of the effluent and those items would be in a 50-50 cost share, which I believe you can see on 3367-0015, the middle section where it says CSI and party proportionate share of improvements, 50% CSI, 50% party. And it says relates to the sharing of the wastewater effluent system constructed for all of Coyote Springs during the life of the existing option agreement.
Okay. And so what is comprised in the effluent distribution system?
It would be everything that you see in those three bullet points there. It starts with the wastewater treatment plant, and then it's everything beyond that also.
Okay. So we're talking about the permit that we have as 25 relates to the 50-50 split, including the wastewater treatment plant and all necessary other improvements. Is that accurate?
Yes, it would be everything that Coyote Springs Reuse Water Company, which is wholly owned by Wingfield Nevada Group Holding Company, that was spending for that permit and for its efforts and work to accomplish that, the treated effluent system.
Of the $27 million, do you know who paid all or any portion of that amount of costs incurred in the development?
I do not. Sitting right here, we'd need to really get into some of the damages numbers and accounting records.
And we'll look at that when we finish. If I would, I think it's been admitted, but I would proffer state proposed 25.
No objection. Okay.
At 250003, there's a reference to in item number 7, the extension of time application. And the purposes and reasons therefore, and it appears to say that in part it relates to the significant downward change in the real estate market. A reevaluation of initial infrastructure needs was conducted. Do you know what Mr. Savory is indicating by including that in his supplement?
Yes, this is what I described the other day, and during cross-examination, you and I spoke about this, and then this paragraph goes into a more coherent description of the transition from the decision to build out the initial 2.1 million gallon per day full wastewater treatment facility to the package plant, which is in the last paragraph on this page.
Okay. But that $27 million expended, as I understand your testimony from reviewing the JFI, is not something that the state engineer required to be expended. Is that accurate of your testimony?
In order to have treated effluent, which we were required to do so that we would not be watering the golf course with groundwater, we would have to create a treated effluent system and treated effluent distribution system.
I appreciate your response, but I'm talking about the direction to do those improvements. I understand that they need to be done, but from the direction of the state engineer or mandate or order, that's not something the state engineer required CSI or party to do. Would you agree with that?
Before it was ever constructed, I could see where an answer to your question would be, that would be correct. However, once Coyote Springs Reuse Water Company received a permit, then Coyote Springs Reuse Water Company would have to then build and correctly have a distribution system that handled all of that treated wastewater, the treated effluent correctly.
In order to use the water that's permitted, CSI had to construct an improvement. Right?
I suppose, I mean, that's not exactly what I said, but I don't think I will disagree with it.
I mean, CSI had a choice to build it or not to build it. Would you agree with that, gentlemen?
Not if it wanted to have treated effluent.
Brendan, may I have states, I'm sorry, states proposed 24? I think you stipulated actually. Like this 24.
It's in.
And can you identify this document, Ms. Cargill?
This is an application for extension of time to file a proof of completion of work for the owner of record, Coyote Springs Reuse Water Company, for permit 77340 supplement 02, which is -S02, which is for reclaimed water from the Coyote Springs Water Reclamation Facility.
And at least pursuant to this document, is that the same permit number that we just looked at?
Kind of. There were 2 supplements filed, maybe 3. I can't remember right now if it was 2 or 3 supplements. So you have the base 77340. Then there's S01, supplement 01, and S02, which this is supplement 02. I can't remember if there was a supplement 03 or not, but each time an application for extension of time to file a proof of completion of work would be done, you would have to file one for each of 77340 and the various supplements to it as well.
When we look at the total to date on this page is how much?
It says last year, $725,000. Total to date, $28,578,000.
These are both dated the same day. So the numbers, though they relate to different permits, are still referencing essentially this single treatment plant necessary to treat the effluent water. Would you agree with that? In other words, they don't aggregate.
Are they different dates? This is 2011 was the one we just looked at, 2010 or 2011? A moment ago, the one we looked at.
A moment ago we looked at was, I think 2011. Let's go back, make sure we're on the same page. That's 10.
Well, look at the date it was received is my point, Mr. Sylvester.
Okay.
It says January 2011. I
Okay.
agree, Mr. Savely signed it in December. This one says it was signed December 30. I just don't remember. And perhaps they are the same. I just don't recall right now.
Okay, but as it relates to the amount, the total to date is the 20, go back a little bit up, Brendan. That 28,578,000, even though there are 2 different permits, it still relates to the same improvement costs associated with creating that wastewater treatment plant and ancillary necessary improvements?
Because sitting here today, I don't know exactly what numbers Carl used to come up with that number. It's possible that for the uses identified in this supplement, the permit for this supplement, that there were additional costs. I don't remember that, and I know it's crazy, we just looked at it. I do not remember if the exact number total to date was identically 28,578.
And would you, I guess the question I'm asking, and maybe it's just an easier than to compare the exact numbers. Do you know what the total cost, estimated cost was for the treatment plant was going to be?
I cannot remember right now, Mr. Sylvester. It was a very large number. There was a lot that went into all of the underground facilities and equipment. My memory tells me it was in excess of $40 million, but I could be completely wrong on that.
Or not? If we go back to 3957, Brendan, please. And this is a application for permit to appropriate the public waters of the state of Nevada and its Coyote Springs reuse. Return the second page of that document at 002. It has the number 8 water reclamation facility, reservoirs, pumps, and so on. And the estimated cost of works was 42 million.
Well, my memory frightens me. That's all I can say.
So going back, I'm just trying to refresh your recollection. When we look at these permits, whether it's SO1 or SO2, the total to date of whether it be 28 or 29 is in pursuit of that total $42 million. Do you agree with that, gentlemen?
Generally, except we need to remember that SO1 and SO2, and assuming there isn't an SO3, that they actually have slightly different uses. And so I don't know if there's any additional costs that are associated with the base, that particular base permit, or its SO1 or its SO2.
Okay. If we go to plaintiff's 29, please. Seems to be continuation of the applications relating to this one's SO2.
I would agree this is SO2 for 77340.
And this is received in 2012, it's like January 9th.
I would agree.
And the total cost to date was the 29,333,000.
I agree, 29,333,452.
And the amounts in the preceding year is 755,452. At this time, in the January 2012 time period, you were still in the litigation with RD, right?
I don't recall when that litigation commenced.
2011 and finished in 15.
I recall it finished in 15. It had started, if I will take your representation that the litigation commenced in 2011, and answer to your question, yes.
And if we can go to 0002. There's the supplemental explanation provided by Mr. Safely, and it relates to, looks like the same thing, the delays in construction from the downward changes in the real estate market, right?
It does, and it looks like the third paragraph, the one that starts during the past year, it looks like that has a little bit more fulsome information based on whatever was happening at that point on the package treatment plant.
Who's doing that work at that point? Do you know? During litigation?
Pardee continued to do some work. We did not pick up the package plant until 2015, but Pardee did continue to do some work that they had already contracted for, is my very slim memory on that.
When you say picked up the cost, that's after the settlement agreement. Essentially, you settle out with Pardee and everything, that all the improvements they made and all of the licenses and permits and whatever else they own were transferred to to CSI, and then CSI picked them up at that point going forward. Is that correct?
Coyote Springs, Nevada, but yes,
Okay. Well, by the way, when's Coyote Springs, Nevada for?
2015.
And when you say picked up, is that to your recollection, the first time that CSI Nevada or CSI of the entities began to construct improvements in pursuit of constructing that improvement for that wastewater treatment plant?
On the waste on the package plant, yes, absolutely. It was after we got that facility then transferred to us and the rights under it. And we then had to go out and do specific engineering and hired HDR to tell us what the status of it was and what had to be done.
And if I was to try to determine how much CSI spent in connection with conducting the improvements that are set forth, for instance, in that document on the first page of 27 million roughly, I would be able to look at your accounting and your line item entries and pair those to the improvements related to what's referenced in the applications for extension of time.
We would look at the accounting records, yes, and then we would have to look in the accounting records and see what they said. As I noted, I'm not sure what Mr. Savory included in that number. I don't know if he included money that Pardee had spent. I just don't know, Mr. Sylvester.
That's okay. I'm just trying to prompt your recollection on direct examination. As I recall your testimony, every time there was an application to extend the time period to establish beneficial use, CSI understood that as essentially the direction, if you will, from the state engineer to continue to spend money on improving the master plan community. Is that accurate with respect to your testimony on direct examination?
Objection, mischaracterizes testimony.
That's
It
why
says she can address it.
That's a overgeneralization, I think, of what I said. I believe that what I was stating was that Coyote Springs, in order to continue to file applications for extension of time to achieve beneficial use, and in order to get to a place where we could have beneficial use, we had to continue to spend money to complete all of the infrastructure, because the state engineer had already told us that they would not accept as beneficial use our continued dust control irrigation of the golf course. So to have beneficial use, we needed the municipal use of homes, businesses, the municipal development of Coyote Springs to be completed. And in order to have a home, we had to have a water treatment plant. We had to have a wastewater treatment plant. We had to have all the other utilities and infrastructure.
I get that. And what I'm trying to understand, and I appreciate your answer, I'm trying to understand what CSI would have told directly to the state engineer about the cost that they had incurred to date so far in establishing or attempting to establish beneficial use, and what it projected was necessary to establish beneficial use, if you have the foundation for that answer.
I believe that the state engineer was well aware of everything that Coyote Springs was doing and had been for some time, from prior to 2005. I think that's the year when the initial applications related to the detention basins came forth to describe what the downstream community was that had to be protected by those off-site detention basins and all the on-site drainage channels that connected to all of those. I believe the state engineer was well aware of everything that was happening, and it's something that was discussed. It was it was public. We weren't developing Coyote Springs under the proverbial rock. And there were articles in the newspaper, there were it was well known that this was going to be what it was. And I am sure that in all the early meetings with the state engineer about the detention basins and about permits that were going to be filed and all of those sorts of things, that it was discussed with the state engineer and the state engineer staff, that what was going on was happening, and that it was going to be a very large endeavor to get one, let alone 4 municipal wells online and a water treatment plant and a wastewater treatment plant.
Okay, I think I understand your answer, and I'm not gonna try to parse it, but I think generally what you're saying is that it's open and obvious. State engineer knows CSI is spending money to develop a master plan community. Is that an accurate sort of distillation of your testimony?
Objection, mischaracterizes prior testimony, incomplete recitation of prior testimony.
She can address it.
In part, that is a part of what I'm saying. It's open and obvious, but I'm also describing the detention basin. And without trying to remember every word I just said, what I just described about the detention basin and meetings related to that, and other meetings related to the, the drilling of these very significant wells that we drilled, and what the purpose of drilling them was, and all of those actions and activities. A very shorthand way would be to say that it was open and obvious, but that to me is only a very small part of it.
But that actually wasn't the question that started the colloquy. My question was, do you have any information that would have demonstrated to the state engineer how much money CSI was expending to develop the master plan community and how much it anticipated spending?
Objection, that question has been asked and answered.
It was asked, it wasn't answered. She told
She's
me.
answered it to the best of her.
I'm talking about not the fact that it's going forward and the assumption that you're spending money. I'm saying, do you know foundationally if CSI ever on the continuum advised the state engineer how much money it had expended in attempting to develop the master plan community and how much money it intended to spend?
Objection, Your Honor, the question's been asked and answered repeatedly.
It wasn't even close, Your Honor. I mean, she told me how it's open and obvious. I distilled the question, went back to my first one saying, how much money did you tell the state engineer had been spent and would be spent? It's the amount of money, not the actual fact that they're developing these things.
Yeah, Your Honor, she didn't testify. It's open and obvious. Counsel suggested that to her in his question. She said that'd be a very shorthand way for her to refer to probably now half a day of testimony. So,
Your Honor, the question is so simplistic as and counsel is attempting somewhat artfully to mischaracterize it. I'm talking about what did you tell them you were going to spend and had spent in dollars? That's the question.
I believe that question's been asked and answered repeatedly, Your Honor.
Last time.
So I have a memory that we earlier talked about, you and I, at some point, the ruling number is on the tip of my tongue, the Tuffy Ranch hearings, 5918.
5918, you're right.
5918. That in those hearings related to the Tuffy Ranch water, when Mr. Whittemore and Mr. Aguero were testifying to the state engineer, that they described a project of a large dollar amount. I don't remember what the number was, if it was 100 million, 200 million, whatever the number was that Mr. Whittemore and Mr. Aguero described to the state engineer. I just have a memory that that was discussed. And that would have been, and maybe it was in a closing, like I don't even know if they did a brief or there was some document. I have a memory that there was a document that had a number in it, whether it was a closing brief or it was a transcript. I don't remember right now, Mr. Sylvester. And there was that, I think that included a dollar amount about why the Tuffy Ranch water was important to Coyote Springs and what dollar amount was being anticipated for construction and what was being spent at the time. That in addition to everything else I've said, that whatever those documents say, we would have to pull them up and we would have to go through them and look at those documents. But I believe there were those documents. And I don't remember if in the Cane Springs hearings, I am sure, although I don't have a good memory of that Mr. Whittemore testified at that time also. And I also wouldn't be surprised if Mr. Aguero was at his side and they likewise testified something about what Coyote Springs was. And, they're making an appearance before the state engineer and describe what it was and what the status of it was at that time and what the anticipated expenditures were and what the purpose of Coyote Springs was and how large it was going to be. I'm trying to think about any other hearings that may have been where Mr. Whittemore or Mr. Dirk may have appeared before the state engineer also, or Mr. Savely, and describe Coyote Springs.
Okay.
I would generally say there was all that, plus everything else I said
All right.
within the past probably 20 minutes.
The 5918 hearings were allowing the interbasin transfer from Lake Valley down to Lincoln County, right?
Yes,
Okay.
that was yes.
Okay. What started this was, we were looking at the various applications to extend the time period to establish beneficial use. And we looked at a number of those that indicate how much money had been spent and how much money in the last year and how much money total the project. And those are the documents that we spent some time going through. And so I was looking for, and I think you gave me the answer, any other documents that would have supported a direct, if you will, representation to the state engineer that he could consider in determining whether to grant either applications for the extension of beneficial use or any other action the state engineer was going to take. And have you rounded out your answer to that question?
Objection, it's very compounded long.
Sustained.
Right, other than the applications that we have seen that identify specifically the amount of money that had been incurred in connection with the works as they've been described. In addition to your testimony, any other documents that you can reflect upon having specifically advised the state engineer as to how much money had been spent and how much was intended to be spent, including your answer you've already given?
I think I mentioned this, but if I didn't, I don't even know if it's in the record or either of us produced it, but the very early applications and backup documents related to the detention basins, I think I mentioned that. I would be surprised if they did not include a detailed description of what Coyote Springs was, but we would have to pull those up and look at those, Mr. Sylvester. But those would have been made to the state engineer very specifically because the detention basin is under the auspices of the Dam Safety Division of the State Engineer's Office.
What does that mean, under the auspices?
Meaning the state engineer's office has a variety of divisions. One of those divisions is I believe it's still called this. I think it used to always be called this also, the Dam Safety Division, meaning the group of individuals in the state engineer's office who report to the state engineer, who permit and oversee and send me the letters saying what has to be corrected on and then send the bills as well.
Let's talk about the dam. Well, the detention basin is what we're referring to, right?
Yes,
Okay. And the detention basin was built not on property owned by CSI, right?
correct. It's Bureau of Land Management land.
And it's true that the Clark County Regional Flood Control District in Clark County were the agencies that required the detention basin.
I don't know that they required it. They required a means of channeling and controlling potential storm, the 100-year, 1,000-year, 500-year storm flows coming from the west. And that was the methodology that all the engineers recommended. But be that as it may, if that's the choice to decide to build a storm detention basin, it requires the plans to be approved, reviewed and approved by the state engineer's office,
For safety purposes, right?
for the dam safety permit, yes.
But I just want to make sure that you and I are on the same page. I think you've just indicated that you are. The requirement for the detention basin is the Clark County Regional Flood Control District and Clark County.
Objection, this states your prior testimony.
If it does, you can tell me. I'm just trying to understand the requirement to build the dam or the retention basin, and then certainly we'll talk about what the state engineer's role in that is.
Asked and answered, Your Honor.
Yeah,
Mr. Sylvester, I think I said within the past half hour or so that I'm not 100% certain of where the overlap between the Clark County Regional Flood Control Office and the state engineer's office is in the requirements of constructing a facility to protect, as the state engineer's office requires or states, the downstream community.
can I have Brendan, please? States Exhibit 3286. And if you would turn to 0043. Just take a moment to review that and tell me if that refreshes your recollection as to who required the detention basin to be built, if you will.
This refers to Clark County Regional Flood Control, acceptable to county and Clark County Regional Flood Control District.
Thank you.
You're welcome. I just don't know if where the state engineer, there's no question that the state engineer was involved in the design, the redesign, and the approval of the plans.
There's no question in your mind?
I've seen the plans stamped by Mr. King.
Okay. Now, this is predates you, that is the development agreement. Do you know what interaction CSI had during the time period that the detention basin was being discussed with the state engineer?
In this time frame, I thought I saw on the front of this document was 2003. I don't know in the 2003 time frame what the discussions with the state engineer's office were at that time. Is this the current development agreement, Mr.
I believe
Sylvester?
that's 2002.
Okay, I just thought it said a different date on the front.
We can look at it then.
No, that's fine. I just wasn't sure, that's all. You flashed past that page too fast for me.
Rick, can I have plaintiffs 246, please? And this is the looks like an application for approval of the plans and specifications for the construction, reconstruction, or alteration of a dam. Is it still referencing the detention basin?
Yes, that's what this appears to be.
And who is the owner of the proposed dam?
It describes that the owner will be Party Homes of Nevada.
And the date of that is May 2007.
Yes, in the upper right-hand corner, that's the file date.
Is that the intent, to your knowledge, that Party would be the owner of that dam when completed? At least consistent with the application.
They would be the owner of the improvement that would be placed on the BLM land, and at this time, Pardee Homes of Nevada was the applicant and the receiver of the right-of-way permit from the Bureau of Land Management, which following the settlement agreement with Pardee, Coyote Springs, Nevada, assumed that obligation on the detention basin lease.
In 2015, is that what you said?
Yes.
Okay.
Mhm.
So from this, at least from 2007, it is Pardee that's pursuing the improvements associated with the detention basin and deemed to be the owner of the proposed dam, correct? On the BLM property.
Yes, in accordance with the JFIs on that amendment 1 to the single family party agreement.
And that if I haven't, or if it hasn't already been admitted, I would think it has stipulated 246. Thank you.
And that is for Coyote Springs Detention Basin 2. At this time, there were actually 3 detention basins. There was detention basin 1, 2, and 3, which I don't know that 3 had any plans for it, but 1 and 2 had full sets of plans.
Right. Was detention basin 3 ever constructed?
No, it was not. And when Coyote Springs took everything back over in 2015, it was modified to be detention basin 1-2.
If we would turn to stipulated exhibit 247, please. To your point, this is an application for approval of the plans and specifications, and it has Coyote Springs Detention Basin 1.
I agree with you.
Okay. And again, this is Pardee as the applicant, and it was going to be the owner of the proposed dam, or at least the improvements on the BLM property.
I think the applicant is actually GC Wallace and an engineer, Grant Tokayumi at GC Wallace.
Making the application for the approval of the plans and specifications of Coyote Springs Basin 1 to be owned by Pardee Homes in Nevada.
I agree.
The estimated cost you can see at the bottom is $7,406,000. And that is a cost that Pardee was going to incur to the extent that it pursued the development of the detention basin 1.
That is what it says.
Okay. I'm just returning to 246 for a moment, same question. As it relates to the estimated cost of $5,190,000, again, that's going to be the cost incurred by Pardee as the ultimate owner of that detention basin.
Okay, I see on 246, I see the estimated cost of $5,198,178.
And that's the amount that Pardee was going to have to expend to complete at least that portion of the dam or the detention basin. Agreed?
That was their estimate in 2007, yes.
Okay. Right, can I have 268, please? Stipulated admitted 268. You recognize that document?
Yes, it has a confusing stamp on it, but meaning at the bottom of the first page, it says March 30th, 2012. And it's referring to something prepared for Pardee. Mr. King signed it in July of 2017. And it shows received in May of 2017. And so what we're missing is perhaps an assignment from Geocon or from Geocon to Coyote Springs, Nevada, but I know that we used Geocon and Shane Rodeker was involved.
Okay. But again, it's prepared for Pardee Homes as of March 30th, 2012, I should say.
Yes, it was. And it refers to detention basin 1-2.
And you just don't recall today sitting here whether there was ever an assignment of that.
I know there was.
Okay. I believe 268 has also been stipulated into evidence run. Because it is an update of geotechnical investigations to Party Homes, is it fair to say Party Homes is still taking the responsibility of pursuing the completion of the detention basin, to your knowledge?
At least as of the date of the report on the first page, 2012. In 2017, they were absolutely not.
We turn to 269, please. This is the one that's approved by Jason King on the VTN letterhead, is that right?
No,
I'm sorry. 269, go to 002.
yes, I see that.
Do you know what it is?
It's a letter from VTN to the Division or Department of Water Resources. And it's stated to be a drainage report and summary of changes for Coyote Springs detention basins 1 and 2. And it's, I don't know how many pages, but a multi-page report that was approved under State Engineer File Number J-734 by Mr. King on July 24, 2017.
May I have 255, please? And can you identify that document, Ms. Corrigan?
It's stated to be an extension of time for the filing of a proof of completion of work documentation for permit J-600, which I believe we looked at was detention basin 1. And it was filed by someone named Jerry Pruitt, professional engineer, as a consulting engineer for Party Homes of Nevada.
Says 2009, how much had been spent to date?
It's I don't know. I didn't see the date of this document.
At the bottom, Brendan?
Oh, thank you. August 2009. So it says the expenditure on the project under this permit last year was $2,786,944, and the total to date $5,112,000, $112,029.
Okay, so if we then turn to, and by the way, that is J600, right?
Yes, it is.
Does that indicate to you that Party had commenced construction on the detention basin at the time?
Objection foundation.
Sustained.
From your, no. You have some knowledge with respect to when the detention basin was approved and ultimately when it was completed, correct?
Yes,
And you were COO at least from 2011 forward, correct?
in that time frame, yes.
You were general counsel from 2006 through 2011 when Mr. Whittemore left.
Yes,
You reviewed the terms and conditions of the various agreements by and between Party and CSI,
yes,
including but not limited to the jointly financed improvement amendment we looked at.
yes. I didn't negotiate that, but I certainly reviewed that.
And you, I think you testified that you were involved in communications by and between, among others, the state engineer with respect to the plans, approved plans for the detention basin.
No, I wasn't involved in those communications for the approved plans.
And then CSI took over the project in 2015, the detention basin.
Yes, it did.
Do you have any idea when construction on the detention basin started?
Started under who? Pardee or
Started.
Coyote Springs,
Just
Nevada?
started, whoever did it, when did it start?
S- Somewhere at 2005, 2006-ish.
And would you be able to started by Pardee?
Yes, with Coyote Springs's involvement, yes.
All right, so you have the foundation for when it started and you had the foundation for when it was completed, fair?
Yes, I would not want to be held to when it was started without going back and figuring that out more specifically. If it turns out it was in 2007, then it was in 2007. If it turns out it was in 2005, okay, it was in 2005. It was in that very early years.
And you know that for all the reasons we just talked about, correct? In your capacity, in the various capacities.
And because my office was at Coyote Springs.
Okay. And you don't know though, who paid for what portion of that detention basin before Party took it, I'm sorry, CSI took it over in 2015?
I believe that Pardee paid in the early years, although Coyote Springs may have shared in the payments related to the permits to the Bureau of Land Management.
And do you know how much Party, when you say Party paid in the early years, you mean the early years before it was taken over by CSI in 15?
Yes, Coyote Springs may have paid for some of the engineering in those years prior to 2015. I cannot recall. There was something about the detention basins that is sticking in my memory, Mr. Sylvester. There may have been actual cost share related to some of the detention basin payments. I just cannot remember right now. There's something about that that is sticking in my head.
Okay. Were there changes in design ultimately after the recession, to your recollection, by Party?
I believe that's when yes, I believe that's when the change from detention basin 1 and 2 became slightly shorter in terms of length, ultimate length. And from detention basin 1 and 2 to detention basin 1 and detention basin 2 to detention basin 1, 2. And that was somewhat commensurate with the 8th Amendment to the Pardee CSI Coyote Springs 8th Amendment to the Single Family Agreement, because Pardee was no longer going to be starting at what was generally referred to as the lake house, that area up off farther north from the town square area near the golf course. And had they started their homes in that area, they would have had to have had detention basin coverage farther north than it is right now. And so when they moved their day one down south towards the golf course, then that's when they could redesign the detention basin and do detention basin 1-2.
Brittany, can I have 268, please? Brittany, can you go to 467? I think it's page 467 within that report. And if you make that a little larger for us, please. Does that reflect when the whether there had been further construction after 2007? You can see in the middle of the paragraph.
It could be Mr. Sylvester. I mean, I just read that paragraph. I see what it says. I was not at the meeting. I know what it says, and that's as much as I can say right now.
Yeah, but you were there during the same, when I say there, you're on site, as you testified a little while ago.
But
To comport with your recollection.
no, not necessarily. I don't remember what this is that whoever drafted these notes, whether it was Mr. Hannafin or Mr. Giordano, I don't recall what's being described there specifically. I mean, that's some pretty specific construction
Okay.
information.
Can I have exhibit 264, Brendan, please? You know what this document is, Ms. Carter?
Yes,
And can you explain it to the report? Make it a little larger, Brendan, please.
this is a letter from the Nevada Division of Water Resources addressed to me on May 18th, 2023 regarding dam safety inspection of the Coyote Springs Detention Basin 1-2 dam NV 10672 J-734.
And what is the purpose of the letter?
Every year, the state engineer's office comes out, I believe it's every year. And they send someone out who comes out and inspects the detention basin 1-2 dam or whatever the facility is. And it's exactly as it says. The purpose of the inspection was to determine the condition of the structure with respect to dam safety.
And was there an emergency action plan at that point referenced? Says this, the dam is classified as a significant or high hazard, and emergency action plan EAP must be developed, exercised, and updated regularly. Do you know what an emergency action plan is?
Yes, I do.
And that's what something you talked about in direct examination. I think you may have quarreled a bit with the need and necessity to have an emergency action plan at some point on the continuum. Maybe it's the 2023 date. Do you recall that testimony on direct examination?
There was an emergency action plan in place and they simply wanted, they being the state engineer's office, was insisting that it be reviewed and updated and redone.
And I think you testified that, my recollection, that you didn't think an emergency action plan was necessary because no homes had been built.
I don't believe that's what I conveyed. I may have. I believe that my disagreement was that an emergency action plan is required to be done by the state engineer's office by an engineer. And they had an emergency action plan because one had been done. And I did not want to, in 2023, retain an engineer to, at a considerable cost, to come out and pay someone to do that. Ultimately, I did it myself.
You're an engineer?
Absolutely not.
Okay, when you say you did it yourself, what do you mean?
Meaning I took the last one and I had my assistant type it into Word. And then I went through it and did the best I could to update it, given all the information that I knew about what what the state engineer was giving me about it. I typed it all up and I submitted it to the state engineer's office.
Was it approved?
They ultimately sent me a letter and said that they would accept it.
Okay. And why were you doing that in 2023? The trying to update the detention or the emergency action plan after the project had been killed?
Because the state engineer's office was insistent. I think that this was the first of the letters I got, and this is the friendly letter. I believe ultimately they sent me 4 letters, each of which became more and more upset with me until I finally gave in and did what I did.
Okay. I don't know if that answered my question. Maybe you did. I asked you, why do you do it if the project was killed? And I think your response was not to limit your answer because the state engineer required it. Is that accurate?
The state engineer did require it, yes.
Would you decommission the detention basin? Do you know?
Objection foundation.
Hence, do you know? I mean, either you do or you don't. Do you have any foundation to understand whether you could have or whether that was an option available to CSI to decommission the dam?
I don't know if that's a possibility or not.
To inquire?
Of the state engineer's office, no, I did not.
Of anybody?
Have a vague memory that I had a conversation with someone from Bureau of Land Management, and they said that we would have to spend all the money to have all the improvements removed and all the dirt and try to return it to its natural condition. I have this vague memory about that, and that Mr. Sino said to me, why would we do that? That's going to cost a whole lot of money.
Was Mr. Sino at that point, to your knowledge, hopeful that going forward, he would obtain some water to allow him to develop his master plan community?
In May of 2023, no.
You say, I don't know, or no?
I said no.
No. The detention basin is designed to protect whom?
The downstream community of Coyote Springs.
Okay. Does that include, for instance, the folks that play on the golf course?
I suppose if they happen to be there during a 500-year flood, I suppose it could.
People crossing the roadway between the BLM property and the master plan community, would that protect them as well?
I don't know that that was Coyote Springs' obligation to protect people on Highway 93.
Would that water just flow? Do you know? Only if you know, would that water then just flow into the Pahranagat Wash?
At what point?
If no detention basin was built.
Eventually it would, as it would now. If there was, let's just hypothesize, 1,000-year flood, the water would be metered out through the detention basin into the channels on the Coyote Springs property, some of which are a part of the golf course areas. And it eventually then goes through those channels down towards the Pahranagat Wash. That is how that would be handled, is my recollection.
Is the state engineer's approval of that detention basin consistent with your belief that it intended to kill the project?
Objective foundation.
Sustained.
Your opinion, what you've told this court for a number of days, is that the state engineer attempted to and had the intent of killing the project as early as 2018, right?
Yeah, you just sustained the objection
On foundation.
based on foundation.
That's what I'm doing.
Finish the question.
Sure. That was your testimony, right? That foundationally, you believe that as of 2018, May 16th, particularly, that the state engineer intended to kill the project.
Objection mischaracterizes prior testimony, incomplete summary of her prior testimony.
If she can say it does.
Want to rephrase?
Sure. Is it true, Ms. Cargill, that you have taken the position and you have testified in this case that when you received the May 16th, 2018 letter signed by BCP, that you believe at that point the state engineer had killed the project?
Yes,
And I think, if I'm correct, you further believe that all actions taken after that 1303 and 1309 were in furtherance of the state engineer's intent to kill the project. Is that accurate from your foundational opinion?
Objection mischaracterizes a lot of prior testimony.
They just asking if that's consistent with their testimony.
Overruled.
I'm sorry. Can you repeat the
Sure.
question, please?
I think you testified, correct me if I'm wrong, that you also believe that 1303 and 1309 were in furtherance of the state engineer's intent to kill the master plan community articulated in his May 16th, 2018 letter. Is that accurate?
Yes, but I mean, there's a lot that goes into that simple one word that I've said before over the past however many days, 8 days, you and I've
I
been
understand.
doing
I don't want to
this.
limit your answer. And so when the 1309 was issued and the state engineer indicated that the map couldn't be approved because it may exceed the pump limitation, was that also, in your opinion, in furtherance of his intent to kill the project?
Are you speaking about the June 2020 letter,
Yes.
June 17 or 18, whatever it was? The June,
Yeah, sorry, after the 1309 was issued?
yes. I'm sorry, I'm just getting tired. What was your question?
Talking about the intent to kill, going in furtherance of the state engineer's actions that you believe were in furtherance of that intent. Can we talk about 1303, 1309, and are talking about the denial of the map based upon the fact that at least the state engineer's position may exceed the pump cap limitation. Was that action also in furtherance, in your view only, the state engineer's intent to kill the project?
Your Honor, this has been the subject of probably dozens and dozens of questions after 8 days.
It has. What
Well,
the question started with is the detention, the approval of the detention basin consistent with her opinion that the state engineer intended to kill the project. Now, I had to lay the foundation because apparently the COO and general counsel didn't have that, or at least it hadn't been articulated. So I've now done that to get to the question that I started with, was whether or not the approval of the plans for the detention basin is consistent or inconsistent with Ms. Cargill's opinion that the state engineer had intent to kill the project.
Well, Your Honor, counsel can say repeatedly that he's laying the foundation. What he's not addressing is the fact that Ms. Cargill's been on this witness stand for 8 days now and has repeatedly addressed this point. And I'm objecting because it's an attempt to summarize her deposition, or excuse me, her trial testimony over 8 days with a single question that mischaracterizes and leaves incomplete her prior testimony on this subject.
If it does, she can say so, Your Honor. I've laid the foundation for the answer. She says, I don't know, I'll accept that answer. If I do know, I'll accept that answer. But suggesting that the timeline is incorrect, she's now agreed that every point on the timeline, that was her opinion that they intended to kill the project. And now the final question is the approval of the detention basin consistent or inconsistent with her opinion that the state engineer intended to kill the project?
Did you say that was the final question?
If I get an answer.
Your Honor, you've heard my objection. We've been here for a very, very long time. This subject's been exhausted. What I'm concerned about is using then one question after 8 days of testimony and then saying, see, this encapsulates in one question, a yes or no question, all of her testimony. It's just unfair, and it's a mischaracterization of a lot of prior testimony. You hear my
The
position.
final version, okay?
Okay. I get an answer. Go ahead. You understand the question? We've talked about it. You've heard Mr. Hutchinson's narrative. Do you have an answer to the question?
You asked me if the detention basin plans, Mr. Sylvester, which were approved by Mr. King in 2017. That's what your last question was. I'm not being argumentative. Please go back and look. I am pretty sure that is what you just asked me.
Okay. How about that? Would that be consistent?
That was in 2017, June, I think.
All right. If that's what you understood the scope of the question, I'll ask a different question, a different time period.
That is what I thought the scope of the question was.
Okay. And your answer is?
In June of 2017. Before the May 16, 2018 letter, no, I don't think they were trying to kill the project in June of 2017, which was before the May 16th letter.
The question actually was in connection with the action plan that you prepared and interlineated without the need for necessity for a engineer that ultimately the state engineer accepted. Okay, so do you need me to repeat the entirety of the question again? And now we're just focusing on the approval of the emergency action plan that you indicated was submitted and approved by the state engineer?
Yeah, I'm just objecting. There's a lot of information in that statement by council, so I
Sustained.
Okay,
don't know what the question is.
I'll do it again. And again, she understood the question to be a different time period, Your Honor, and I'll lay the foundation again for now what I understood and what I did say as it related to the approval of the emergency action plan.
Did you
by-
state a date for that?
June 29th, 2025 is when it was submitted.
It was submitted, when did I submit it? I don't see that in front of me right here.
We can look at 275.
Thank you. I see, I'd forgotten what year I had submitted it.
Okay, and then I think if we go to 476, there's some interlineations on the emergency action plan. I assume those are yours. Tell me if I'm wrong.
On what?
At 476, I'm sorry, 476,051.
I'm sorry, all that's on the screen is my letter.
476, Brendan? Yes, states. I'm sorry, plaintiffs. 051.
I'm not sure. Whose interlineations those are, they could have been mine if we had. But I see GC Wallace in the footer, and that's the part that confuses me, Mr. Sylvester. These could be my interlineations, maybe my assistant converted a PDF and that was in the footer. I have no recollection at this second.
Okay.
Of it. Those could be my interlineations, I don't remember.
Which would have been then on or after June 29th, 2025, when those emergency action plan was approved by the state engineer. Will you agree to that timeline?
On or before, yes.
So back to my question, and I'm happy to repeat it as closely as I can, now that you understand the time period that I'm referencing, the 2025 time period. Is the approval of the emergency action plan provided by you to the state engineer consistent or inconsistent with what you believe was the state engineer's intent to kill the project?
It's consistent because the state engineer, it was ridiculous that they were asking us to do something. I believe my cover letter identified that they were asking us to do this, and upon advice of counsel, we took the steps we took.
Okay. You know how often the state engineer comes out to inspect the detention basin?
It's my understanding they come out once a year. They don't tell you in advance, they just send you a letter afterwards.
And as I recall, and correct me if I'm wrong, is it Meadow Valley that did that work to complete the detention basin?
They were the general contractor that Coyote Springs, Nevada hired, yes.
And they were hired, we looked at it in 17, completed that work in 2018, correct? Your best recollection.
Hired in 16 maybe, but either way, the contract is the contract. I know that Mr. Hutchison and I looked at that contract, so I know it exists.
So close. Brenda, can I have state's proposed exhibit 3468? Can you identify that document?
It came out of our records, I see that. It looks like it's a document prepared by Mr. Savely in 2011.
So do you know, well, I'll offer proposed exhibit 3468.
No objection, Your Honor.
Admitted.
And this is styled summary of non-Coyote Spring Valley water rights owned under contract or potentially under contract by CSI for the benefit of the development. And then it has the references the owned by CSI. Remember a long time ago when we started this, I asked you if you had some understanding as to the water rights owned by CSI, and you couldn't off the top of your head recall what water rights it owned.
I don't remember that conversation. I was just reading. I apologize.
Well, let me ask you today, I mean, just, and at the risk of drawing another asked and answered objection, do you know, sitting here today, how much water rights are owned by CSI
Not
or its affiliates?
Not if I have to include the Tuffy Ranch water. I mean, meaning I know that there's 11,300 acre feet, but I have gone back and I have looked and I know more or less what's owned, yes, by Coyote Springs
Okay,
Investments.
and what are those water rights owned by Coyote Springs Investment as of today's date?
So as of today's date, it would be if I include the GID water, the 4,140 acre feet in basin 210 that come from the base permit 46777.
Okay.
Then then we'll talk about Cane Springs. So you have Cane Springs and there's the 1,000 acre feet, which is split up as follows: 249 acre feet owned by Coyote Spring Investment, 251 acre feet owned by Lincoln County Water District for the exclusive use of Coyote Springs in the Coyote Springs community. And then there's the 500 acre feet of option water rights that Coyote Springs has the exclusive option to purchase from Vidler Water Company. They're owned, the 500 acre feet's owned by Vidler, but we have the exclusive option. So those three numbers added together are, if not 1,000, they should be 1,000. It's just because I'm not including the decimals. And then there are the water rights in basin 219, which is the Muddy River Springs area, and it's about 20 acre feet of water.
Just interrupt you. When you say in the Muddy River Springs area, is that a permitted water right, or is that part of the Muddy Valley Irrigation Company shares?
I believe that's certificated, actually.
Okay.
And then
I'm sorry, I want to get clear. Rather than have you go back, I'll stop you if I may, just so I have better understanding. It says 20 acre feet of certificated water.
I believe it's 20 and change acre feet of water certificated. I believe that's a certificated right.
Do you know when that certificated right was acquired and by whom? Or for whom? From whom, I should say.
I don't know from whom it was acquired. Sitting right here today, I would have to go back and do more research
Okay.
to know that. Or perhaps the schedule that's on the screen may even tell me, I don't know.
Okay.
And then in basin 218, which is called California Wash, there's another 24 or 25 acre feet. I believe that's permitted water. And those two rights in basin 218 and 219 are for the benefit of Moapa Valley Water District and or the DACE, and related to some supply agreements. It has some name like supply agreement or backup supply agreement, or it's an agreement that's related to the 2006 MOA, but they're for Moapa Valley Water District.
Okay.
Or the use for mitigation for Fish and Wildlife Service. And then there are the shares in the Muddy Valley Irrigation Company, which we refer to as the MVIC shares. They're shares in the corporation. There are 16 point something shares of preferred stock and 19, I think 19 even shares of common stock. And those water rights are for use in the Muddy Valley Irrigation Company district, meaning within the ditches, you have to have a piece of property that abuts and has a gate or other conveyance onto your property. And those water rights were acquired by Coyote Springs Investments because Coyote Springs Investments in early years had the use of a tree farm that was in the Moapa Overton area, and that water was used to water the aforementioned trees. And then I already talked about the Tuffy Ranch water, and I don't remember the full quantity, Mr. Sylvester, other than to say there's the 11,300 acre feet that are permitted or certificated for Coyote Springs.
Okay. And that's the sum and substance today, as we sit here, of the water rights owned, to your
That's
knowledge.
the ones I can remember that I looked up the other day. If I've missed one, I may have missed one, but and I didn't include the 460 acre feet that we relinquished for the Moapa Days. We don't really, it's interesting. I believe the state engineer has Coyote Springs is still under our ownership, but it shows that Coyote Springs relinquished it. So I'm not really sure on whose side of the ledger that should go, but it's for the benefit of the Days.
Okay, so going back to the exhibit we're looking at, which is 3468.
Is there a date on that?
The footer, Your Honor, says 2011. And I think that as we walk through this, you just talked about the 28 acre feet in basin 219.
Yes,
And then what is the basin 205 with the 570 acre feet?
Coyote Springs does not own that water any longer.
What was it when it owned it?
I believe that water was. Oh, we had I think that we called that the Rocks water, ROX, but I can't remember. That was water in basin 205, which I believe is called the Upper Meadow Valley Wash. And we gave that water, sold that water to Lincoln County Water District in exchange for no longer paying Lincoln County Water District a standby fee to hold the 251 acre feet under the Lincoln County Vidler Coyote Springs agreement, because we had been paying Lincoln County Water District $15,141 or something like that a month. And several years ago, Mr. Sino III negotiated with them to convey that water to Lincoln County Water District in exchange for no longer having to pay that $15,000 a month.
Was that basin 205 within the super basin?
I don't think so. I think that the Upper Meadow Valley Wash was left out of the lower White River flow system. We'd have to go back and look at Order 1309, Mr. Sylvester, to make sure that my memory of what 205 is not incorrect.
I think you are correct. I think it's outside. Was that water available for use if it's outside of the basin within the master plan community?
We would have to read what Mr. Savely said here. I believe that it was that Mr. Savely had contemplated that water could be mitigation water under the 2006 MOA. And my recollection is that Fish and Wildlife Service said that they did not want the water. There was some reason having to do with it was alluvial water or something, and they did not want the water.
See here today, you don't know if that water was or wasn't available to support the master plan community. Is that an accurate statement?
Until Fish and Wildlife told us they wouldn't accept it, mitigation water would have meant that then the 460 acre feet wouldn't have had to have been relinquished if this Basin 205 water could have been used as an alternative.
But essentially you sold that water to Lincoln County, or in exchange for no longer requiring to make payments along the continuum in the Lincoln County bid their agreements with CSI.
That's correct, because Fish and Wildlife said they wouldn't accept it.
And then 218, that's I think the water you talked about earlier. Is that accurate? The 25 acre feet?
Yes, oh, and it refers it to as the Wheeler water, and that was the water, and it's pursuant to, I thought it was also something, or the records that I looked at said that it was for Moapa Valley Water District pursuant to the backup water supply agreement, which is referred to in the top paragraph on this page.
Okay. And then under Money Valley Irrigation Company, you indicated that there was preferred shares representing 133,9272 acre feet of water.
I have no idea where Mr. Savely got that conversion. I just don't have any knowledge of that at all. I see that's what Mr. Savely wrote. I only referred to the 16 preferred shares and the 19 common shares.
Right. But when you were referring to it earlier, 16 preferred shares, you weren't referring to the acre feet of water associated with those shares.
I don't know where he got his conversion rate to get there.
And then there's the common shares, 19 is 14.4, so roughly 177, 180 acre feet of water in MVIC shares. Is that right?
I would probably add those together and come up with closer to 145 or so.
You're right, 145. Is that water available to be used for the master plan community?
No, because it's in the ditch system, and I say that word very generally, ditch system. It's not all a ditch system. Some of it's pipes and other things, other conveyances.
Okay. Did you ever seek to trade that water with any other water rights on the Muddy River to make that water available?
No, we've not tried to trade it for the Muddy River.
So CSI anticipates exchanging these shares with SNWA for water rights appropriated within the Coyote Springs Valley. Was that ever done?
I don't know if Mr. Savely ever had a conversation about that. I had a conversation with Mr. Ensminger about that.
Okay.
And it did not happen.
All right. And then we talk about the Tuffy Ranch, and there's a number of permits. And is that the 11,300 acre feet?
Yes, as it says in that second sentence.
Then under the next page.
Let's take our afternoon recess now.
Yes, Ron.
And we'll get to the next page. Okay.
Yes.
You can meet at 3:30.
Thank you, Your Honor.
All right.
Alrighty, well, you heard that. We'll be back at 3:30 p.m. We're going to take a short break in the background. I am working on digging into Rich McKay in Eureka County, taking a look at him. Somebody said, oh, I hope that Winterhawk doesn't start doing what he does and look at Eureka County, which it's like just telling me to go look at Eureka. I think they know what they do when they do that to me. They're like, I hope he doesn't go look at John Casanelli and all these organizations that he's part of. I hope he doesn't go look into Nick Beaton. Ooh, I hope Winterhawk doesn't look into Pamela Carson inside of White Pine County. I hope he doesn't. Come on, just tell me to go look at it. Don't be like that. Don't be silly. Just tell me why. Hit me with the DM. Don't be so secret squirrel about it. Let me know what's going on. Anyways, we're going to put out the afternoon update for the court case. I'm going to put on a song here. You know, it's funny, this song. Pay attention to the words of this song, because this song is about a water situation as well. And the lyrics are written for a specific reason, talking about what data centers are actually all about. So we'll be right back. Look forward to that afternoon update for Coyote Springs versus Nevada. This is W4Nevada Live's continuing coverage of Coyote Springs LLC versus State of Nevada, Day 9, afternoon. We'll be right back, and thank you.
Y'all keep looking at the cloud, looking at the concrete, yeah. It's built. Build it, build it, build it. They ain't betting on the build out. They ain't betting on the build out. I'm looking at it. They ain't betting on the AI, they betting on the build out. Everybody found a lane, everybody pull a bid out. Cloud in the headline, dirt in the back lot, survey in the rendering, those are on the blacktop. One set of acreage, one move to water rights, one run transmission, one build overtime, one pour of concrete, one moving the steel, one drawing blueprints, one closing the deal. One shaking hands, one signing the lease, one cutting ribbons, one collecting the fees. Everybody yelling innovation in the room, funny how the money show before the servers ever do. They don't need a tenant if the land already flipped. Whole neighborhood changed before the first chip ship. They selling you tomorrow while they graded today. Different route to the money, but the money move the same. Clouds in the sky, money in the ground. Same names at the table every time the vote comes down. Different logos on the door, everybody wants a cut. They ain't betting on AI, they betting on the build out. Own it, stamp it, watch the numbers climb. Call it innovation, I just follow every line. Clouds in the sky, money in the ground. Follow every dollar, watch the whole thing circle around. Build it, build it, build it. That they betting on the build out. Build it, build it, build it. Watch the whole thing circle around. Planning move the boundary value, jump overnight. Commission raise a hand and the graders hit the site. Public hand packed, got so polished and prepared. 3 minutes at the microphone, years moving under there. Your business fits the bill, put the ties in the light. If investments touch the zone, put the maps on the mic. I don't need a room, I let the filings do the talking. LSC's disclosures, who was buying, why they zoning. Need another substation, another invoice born. Need another gas line, another right-of-way drawn. Road surveys, permits, engineering fees. Consultants billing hours to explain what we can see. Tax break, tax cap, tax credit, tax waiver. Funny how billionaires still need another taxpayer. They leave with all the dope and never label what it costs. Everybody settle when nobody volunteer the laws. Clouds in the sky, money in the ground. Same names at the table every time the vote comes down. Different logos on the door, everybody wants a cut. They ain't betting on AI, they betting on the build out. Own it, stamp it, watch the numbers climb. Call it innovation, I just follow every line. Clouds in the sky, money in the ground. Follow every dollar, watch the whole thing circle around. Yeah, they betting on the build out. Build it, build it, build it. Watch the whole thing circle around. Who sold the dirt? Who moved the line? Who owned the company at decision time? Who held the water? Who wired the power? Who made the motion? Who built the hour? Read the minutes, read the maps, read disclosures, read the taxes. Grand conflict, put it all in the light. Public trust don't come from saying we did everything right. Government crack the gate, utility feed the line. Chamber cut the ribbon, local paper sell the shine. Consultants call it progress, developers call it scale. Residents ask about the water, get a brochure in the mail. Different band, same room, different chairs, same fold. Different promise in the headline, same clause in the note. Different handshake, same decision underneath. Everybody showing teeth, I'm shaking every receipt. Cloud got your daisy concrete, got the check. Everybody looking forward, I'm just following who's next. You can keep the servers, I'm tracking every bid. Money hit the counter before data ever did. I don't hate the future, I just question who it serves. When the public takes the risk and the private keeps the perks. I don't chase rumors, I chase dates and signatures, paper trails. Stay quiet till the bulldozer confirms them. They can call it progress, they can call it moving fast, but the future ain't the future when it's owned by the past. Every road, every pipe, every contract getting routed. They ain't betting on AI, they betting on the build out. Clouds in the sky, money in the ground. Same names at the table every time the vote comes down. Different logos on the door, everybody wants a cut. They ain't betting on AI, they betting on the build out. Own it, stamp it, watch the numbers climb. Call it innovation, I just follow every line. Clouds in the sky, money in the ground. Follow every dollar, watch the whole thing circle around. Read the contracts, read the minutes, read the names behind the business. Read the filings, read the routes. They ain't betting on AI, they betting on the build out. Build it, build it, build it. Watch the whole thing circle around. Y'all keep looking at the cloud, I'm looking at the concrete. Do Fresh white box, clean lace tuck. Bad luck if I step too tough. Tile floor, I move like one wrong crease and it ain't right. Corner store, I slide through. Old heads not like dating new. I keep it smooth, I keep it low. Every step on tiptoe. Hold it back, don't rush now. Hit that snap, move hush now. Tiptoe down the street, so my Jordans don't crease.
Tiptoe down the street.
Yeah, easy on me. Tiptoe down the street, so my Jordans don't crease.
Tiptoe down the street.
They all know the routine. Tiptoe down the street. Tiptoe down the street. Curb too high, I pivot slow. No scuffs on the toe, let it go. Pavement cracks, I pick my line. Keep that pair in a perfect shine. Man on the block say how you glide. I say man, I don't waste no stride. New day fit, old school pride. Won't let one bang kill my vibe. Hold it back, don't rush now. Hit that snap, move hush now. Tiptoe down the street, so my Jordans don't crease.
Tiptoe down the street.
Yeah, easy on me. Tiptoe down the street, so my Jordans don't crease.
Tiptoe down the street.
They all know the routine. Tiptoe down the street. Tiptoe down the street. One wrong step, there's a heartbreak. So I glide like a clean break. Slow motion when I cross that line. Fresh pair, I make a mine. Tiptoe down the street, so my Jordans don't crease.
Tiptoe down the street.
Yeah, easy on me. Tiptoe down the street, so my Jordans don't crease.
Tiptoe down the street.
They all know the routine. Tiptoe down the street. Tiptoe down the street. You said I'm cold, but you made me that way. Too many faces, too many okay. Same old smile with a new little price. I seen the fake side turn ice to ice. I've been through the noise, I've been in through the shade. Learn how to read what the real ones trade. Everybody want shine, nobody want pain.
I keep my heart in the back of the frame. Hey.
I was lit once, now I'm on hush. Too many hands, got my trust in a crush. Old school hurt with a new school twist. I don't miss much, but I miss when it hit. You come close, then you fade. I don't move, I used to move. I hear love, but it sound like play. So tell me what you're trying to prove. So jaded, I gave too much, now I'm faded. So jaded, you want the old me, you can't take it. No. So jaded, heart on ice, but it still made it. So jaded, I've been let down, now I'm waiting. Seen it all like a rerun scene. Big screen lies in a small screen dream. Everybody dressed like they run the game, but the same old script got a different name. I've been Michael off the wall, still smooth. I've been Neo dodging what I can't lose. I've been Prince with a purple bruise. I've been Pac with a lot to prove. She said, baby, why you talk so dry? Cause a sweet word dies when it's overused. I still want love, just cleaner now. Let's talk more truth when you step around. Come close, then you fade. I don't move, I used to move. I love, but it sound like trying to prove. So jaded, so jaded. I gave too much, now I'm faded. So jaded, so jaded. You want the old me, you can't take it. No, no. So jaded, so jaded. Heart on ice, but it still made it. So jaded, so jaded. I've been let down, now I'm waiting. I'm not bitter, I'm just bruised. Different lessons, different views. If you real, then say it straight. If you fake, don't test my gate. I still feel it when you call my name. Still a spark on the artist rain. But I learned how to close that door. Can't buy back what I gave before. So jaded, so jaded. I gave too much, now I'm faded. So jaded, so jaded. You want the old me, you can't take it. No. So jaded, so jaded. Heart on ice, but it still made it. So jaded, so jaded. I've been let down, now I'm waiting. So jaded, so jaded. I still feel it, but I don't chase it.
We're at that 3:30 already. I'm just in the background, dancing to this original music, wait for the court case to come back. That's how I started. Tell them that they gotta get better, not bitter.
Get better, not bitter. Bitter, 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 bitter. Get better, not bitter. Bitter, bitter, bitter,
Hey, hey, you talk big, then you fold quick. New phone, same old joke click. I seen that look on your face when the truth came through, no space. Yeah, you was all flash, all chatter. Now your whole little world looks shattered. I don't chase, I don't beg, I don't plead. You the type to drown in your own greed. Saw you post like a king, then vanish. Big talk, small steps, can't manage. Late
And we're back.
run, same scene. You keep, but you
Please be seated.
stuff.
We're back on the record.
And we were at 3468002. We were rounding out the discussion on Tuppy Ranch. And then we're going to turn the page and talk about item 3. And there was a note at the top. Just read that into the record, please.
We're on page 2.
Page 003.
Can we make it a little bigger? The page is just a little blurry. Thank you. Note, the project is scheduled for a 40-year build-out. Consistent with traditional municipal planning, CSI anticipates sufficient water rights being made available to the project in multiple increments over time. CSI intends to maintain a 3 to 5 year lead time for having sufficient water available to meet expected demand.
And then the last category is CSI and Lincoln County Water District and Bidler groundwater development in basins other than Cane Springs. And what is that reference? If you look at the last full paragraph, just read that into the record, please.
Lincoln County Water District / Bidler have indicated they will likely focus their next efforts at developing water rights in the Garden, Cole, and Payrock valleys. Lincoln County Water District have pending applications for new appropriations of 39,000 plus or minus acre feet of water within Garden Valley, 34,700 plus or minus acre feet annually within Cole Valley, and 56,400 plus or minus acre feet annually within Payrock Valley. These valleys have been selected due to their proximity to the regional pipeline that will be constructed by the SNWA and the assistance from natural terrain and the delivery of water from these basins to the SNWA pipeline. It is anticipated that a significant portion, if not all, of the water appropriated from these basins will be made available to serve the CSI development. At present, there is no agreement in place for the purchase of water from these basins.
Do you know what that paragraph references generally?
No,
Is it true, Ms. Cargill, that you never, or you have no recollection of ever advising the state engineer that the only water CSI had available was the 4,140 acre feet in the Cane Springs water?
that was the only water that we had available?
That was the only water you had available?
That we never told that, I'm sorry.
I'll
can
take
you-
it. Yeah, volume 4, Ms. Cargill.
I'm not sure. Let us look. Yes, I do. Which page?
I'm getting there.
Okay.
Brandon, can I have volume 4, page 31, 20 through 23? And then 32, 1 through 8. Actually, take it all the way through 32. 1 through 17, please.
All right, so going back to my question, as it relates to the representations made by CSI to the state engineer with respect to the availability and sufficiency of water, did you ever tell the state engineer that the only water available for the development of the master plan community, at least on the Clark County side, was going to be the 4140 water and the Cane Springs water?
Check to the form of the question asked and answered.
Overruled.
I can't say that I recall that we said exactly it was only that, or that it wasn't only that. We would need to look at all of the communications that took place at that time. I don't believe that I ever said anything otherwise. However, I can't sit here today and say that there isn't a piece of correspondence that doesn't say otherwise. We would need to look at all the correspondence that went to the state engineer's office related to those maps.
Brandon, may I have state's proposed exhibit 3414? 255. After. And tell me, I'm sorry, Brendan, proposed trial exhibit 3414, please. What are we looking for? I thought it was trial exhibit 3414. Let me confirm it. I'm sorry, Brendan, let me try again. Trial exhibit 3310. And tell me, Ms. Cargill, if you recognize that document.
Who signed this letter?
The signature page, Brendan, please. You see it signed by Mr. Whittemore?
I do see that.
You recognize this document?
I don't, I certainly didn't see it contemporaneously. And because I wasn't employed yet. I don't recall if we saw this earlier, either in my cross-examination or when I was on direct. I feel like I've seen this letter before, meaning a letter from Mr. Whittemore to Mr. Riley as county manager. I don't recall if it was this letter or a different letter.
Okay, in May, if I can refresh your recollection, this is a document that was presented to Mr. Whittemore during his deposition. Do you think that's where you recall having seen it?
That could certainly have been the case. I just don't remember at the moment. It's not a document that rings a lot of bells in my head right now.
Offer states proposed exhibit 3310.
No objection, Your Honor. Admitted.
In the first full paragraph, would you read into the record that sentence begins, as you know?
As you know, CSI controls approximately 42,800 acres of undeveloped property within Clark and Lincoln County, east of US Highway 93 and north of State Highway 168, and is commencing development of those properties. The southern portion of the property, consisting of approximately 13,100 acres, is located in Clark County. The balance of the property, consisting of approximately 29,700 acres, is located in Lincoln County.
Now, if you turn to 0003, please. 0003, Brendan. I want you to read into the record the 3 bullet points, the first 3 bullet points. Starting with CSI is continuing.
CSI is continuing to purchase or invest in the acquisition of water rights to meet the needs of the entire community above the amount already held for all of phase 1 development, including the first 3 golf courses. CSI owns 4,600 AFA parenthetical acre feet annually and parenthetical of water right permits within the Coyote Spring Valley. CSI has pending water applications for an additional 108,000 acre feet annually of groundwater from points of diversion within the Coyote Spring Valley. CSI has also finalized or is in the final stages of finalizing additional land and water purchases within the region, equaling over 37,500 AFA of certificated water rights and over 15,000 acres of land. Bullet point 2. CSI has entered into an agreement with a private local water company with the intent of providing wholesale water to the Coyote Springs General Improvement District for potable distribution to the community. In addition to working directly with the Lincoln County Water District, this private water company brings the potential for up to 50,000 AFA of banked water rights that may be used for Coyote Springs. They have placed an initial 2,000 AFA of water in the partnership for use within the Coyote Springs Phase 1. Bullet point 3. Based on the estimates outlined above, CSI is in control of over 87,000 AFA of current water rights and 108,000 of pending water applications. CSI and its affiliated water companies collectively will hold substantial water assets in excess of what would be required to meet the comprehensive needs of the community.
And do you know, excuse me, the letter is directed to the Clark County manager, Tom Riley. You see that?
I believe that's who it was addressed to,
And
yes.
do you know what the Clark County manager is, or what that role is?
That person is the county manager. I mean, I'm not really sure what you're looking for.
What is his role? What does a county manager do? Only if you know.
I don't really know what the Clark County managers, all of his or her responsibilities are.
Did you know, at least as of the time you became employed in 2006, that CSI had represented to the Clark County manager that it had 87,000 acre feet? It in control of over 87,000 acre feet of water.
I don't know that I saw this letter at that time, Mr. Sylvester. I know I have seen other if maybe, and maybe it was this letter where I saw it, I just don't remember right now. I've seen other similar statements.
Do you have some understanding that that's an accurate statement one way or the other as of the date that it was written?
Mr. Whittemore, in my opinion, would not have stated so if he did not believe that that was the case.
Did you understand him to say that he had 87,000 acre feet of water in CSI's control to service the master plan community?
The letter speaks for itself. I mean, there's a lot of pages to this letter and we've only read a few bullet points, and I'm not inviting myself to read more of the letter, but there's a lot of pages in this letter and it speaks for itself.
Okay. But
It's in.
okay. Changing topic just for a little bit before we get to our final category of questions. We were talking, you have talked a lot about the 2006 multi-party agreement, and it was amended in 2015. Do you know what document I'm referring to?
The document that creates the agreement between the Las Vegas Valley Water District, Clark County Water Reclamation, and Coyote Springs, that agreement?
Yeah, that agreement that in paragraph 10 of the 2006 and 11 of 2015 required, in your view, the GID, the general manager, to issue a commitment or certification to the state engineer with respect to availability of water. That document generally.
I know the document you're referring to.
And I think you indicated that you didn't believe that those documents required the issuance of a will serve to the state engineer. Did I get that testimony correct?
That the multi-party agreement did not require a will serve, that the multi-party agreement, we'd need to pull it up, but it says what it says about that.
One of the things we looked at was the conditional approval in 2018. And one of the conditions was a will serve letter from the water purveyor. Do you remember that conditional approval in 2018?
I more or less recall the conditional approval letter. I don't remember the exact requirements
You don't
set
remember?
forth in it.
My apologies. You don't remember the reference to the requirement from the state engineer for a will serve letter from a purveyor? I'll bring it up if you need to see it again, just to refresh your recollection.
I don't remember that it specifically said that we had to provide a will serve.
Okay. Do you recall that the state engineer has always required, at least from CSI, a will serve letter from the water purveyor? When I say always, let's say from 2006 forward, when you first became employed.
No, I can't say that I recall learning that.
Rennie, can I have state's proposed exhibit 3370? If you recognize the document, Ms. Cardell?
I'm not sure I've seen this particular document before or not.
It is dated August 10th, 2006, and that would have been the time period, I think, after your employment. Recognize it generally?
I can describe what it is based on the words on the page. I don't recall having specifically seen this document before.
I would offer state's proposed exhibit 3370.
No objection, Your Honor.
Admitted.
Go to 0002, Brendan, please. If you could read into the record both the general paragraph and that style of action.
General, the tentative map indicates that the source of water is to be from Las Vegas Valley Water District. To date, no letter has been received by this office indicating there is sufficient water for the subject subdivision. Action. Recommend disapproval to the water quantity as required by statutes for the Coyote Springs Parcel 19 subdivision based on water service by Las Vegas Valley Water District until such time that written notification addressed to this office is received listing the water right permits from the water purveyor with an indication that it has both sufficient uncommitted water rights and developed water source capacity to serve the proposed subdivision.
And you see it's copied to Coyote Springs.
I do see that it was copied to Coyote Springs.
We were talking some time ago about the flow, if you will, of how the tentative map finds its way to the state engineer. Does this refresh your recollection that the state engineer, at least as of 2006, required something, a letter from the water purveyor in advance of approving a map?
I see that this letter dated August 10th, 2006 says what it says.
Again, just trying to refresh your recollection as to the flow of, you will, if you will, of a tentative map. Does that refresh your recollection, whether you call it a certification or a will serve, that before the state engineer would approve a tentative map, at a minimum, it had to have a water commitment or certification or letter from the water purveyor that there was sufficient water available?
Objection asked and answered. Overruled.
Mr. Sylvester, this letter does not necessarily refresh my memory. As to that process, I understand all the words that are on the page and what it says. This would have been a map being proposed by Party Homes and its engineer Slater Hannafin Group, but certainly Party Homes was well versed in what it took and how to process.
Do you ever recall telling the state engineer at any point in the continuum when you were involved that a will serve or commitment from the water purveyor, the GID, as with the Las Vegas Valley Water District, was not required, in your view, in advance of approving a map?
I don't remember if I said those exact words. I'm not sure if any of Mr. Chen's emails to Mr. Wilson may have described that generally, or if anyone else at CSI. I don't remember one right now, Mr. Sylvester.
Okay. Brendan, can I have trial exhibit 3418, please? And tell me if you can identify and recognize this document. And Brendan, make it a little larger as it relates to the water commitment. I'm not sure you can read it, Ms. Cargill, on the flush right. Can you read what that says?
I'll try. Water commitment, recordation of the subdivision plat establishes I think that's limited water commitment from Coyote Springs Water Resources General Improvement District, parenthetical CSWRGID, and parenthetical as follows. And then there's two columns. The column on the left says lot number. The column on the right says acre feet per year. The column on the left identifies lots 1 to 11. Column on the right says that's 2 acre feet yearly per lot, which equals 22 acre feet. Column left then says lot A, and it identifies the column on the right as 2.0 acre feet. Column on the left says lots G1 to G5. Column on the right says 2.0 acre feet yearly per lot, which equals 10 acre feet. And below that, it says water facilities to serve the proposed development are under design, but not currently available.
And you see that it looks like it was signed by the Division of Water Resources.
I don't
It's like Robert
see
Cochi,
that.
just above that.
Oh, I see Division of Water Resources certificate. Yes, I would agree that says it's signed by Mr. Cochi on June 23rd, 2008.
And you see where again, where it says water commitment right above that? You could read that where it says NOTC, it looks like.
I don't see where you're referring to.
The
Oh, this
paragraph-
is below that.
Yeah, it's above water commitment.
Oh, okay. Note, the purpose of this division into large parcels is to create boundaries only. There are no permitted or constructed water works, wastewater treatment works, or civil improvement drawing associated with this mapping effort. Furthermore, there is no intent to provide water or sewer services for this plat at this time.
You recognize that this map was approved after it received a commitment from the GID?
There must be, if you're saying that, a GID block on here somewhere. I can't see it right now, Mr. Sylvester, that's all I'm saying.
Okay.
I'm just looking.
No, for state's proposed 3418.
No objection, Your Honor.
Admitted. Middle.
Oh, there it is in the middle at the very bottom.
Can you read?
Can I
that?
read it?
Yeah. Have Brendan highlight it for you.
We have signatures of pull that up.
Clark County, Coyote Springs, Water Resources General Improvement District. It looks like Mr. George Jacoby signed on June 11th, 2008. The Las Vegas Valley Water District, and it looks like Sam Skyer signed on June 10th. I guess that says 2008 for Clark County Water Reclamation District.
Just from a chronological standpoint, that's signed before Mr. Cochi signed, would you agree?
I'm sorry, Council, say that again.
It's signed before Mr. Cochi signed on behalf of the Department of Water Resources.
What date did Mr. Cochi sign again? June 23rd. I would agree chronologically with your statement,
Okay.
yes.
Can I have Brendan proposed exhibit 3402? This is correspondence dated October 18th, 2007. It's directed to Coyote Springs Investment, care of Carter Burgess. And then it has the name of the villages in that section. Do you see those?
Yes, I do.
Right, and then if you would just read into the record that paragraph that is styled general.
Letter dated to 10/12/2007 from the Las Vegas Valley Water District, signed by George Jacoby, Manager, Engineering Services to the Division of Water Resources. States that they will serve water to the subject subdivision. This letter is a matter of public record on file in the Division of Water Resources Office.
Offer of state's proposed 3402.
No objection.
Admitted. Brent, if I can have state's proposed 3423. And this is a subdivision map. And you can see in the middle of the paragraph, it is signed by the Division of Water Resources, Robert Cochi, and just highlight that so Ms. Cargill can see it.
Yes, it was signed by Mr. Cochi on October 18th, 2007.
And then there's the water commitment that's referenced below. You don't need to necessarily review that or read it into the record, but you recognize the water commitment.
Yes, I do.
Okay, and this is now signed after again. The water purveyor has signed it. Would you agree with that?
No, what day was it in September or October that Mr. Cochi signed?
October 18th.
October 18, okay, all right. I would agree it was signed after,
Offer,
or before, excuse me, it was signed before the general improvement district signatures are prior in date chronologically than the Division of Water Resources.
and then if I can have you turn to,
You got all of those.
I'm sorry, offer states proposed 3423,
No objection.
then to 3414, please. It's this letter dated June 23rd, 2008. Second page of that letter is signed by Robert Cochi. He's the chief engineer. And it, once again, in the general section, if you could read that into the record, please.
General, letter dated June 6, 2008, from the Las Vegas Valley Water District, signed by George Jacoby, Manager, Engineering Services, to the Division of Water Resources, states that they will serve water to the subject subdivision. This letter is a matter of public record on file in the Division of Water Resources office.
And the next page, you can see it 002. Just read that action into the record, please.
Action approved to water quantity as required by statute for Coyote Springs Village 1 South, based on service by Las Vegas Valley Water District.
Offer 3414.
No objection, Your Honor.
And then we won't belabor the point, but let's just move for these admissions if they haven't already done so. Brenda, can I have please CSI's 87, please? Okay. This is a subdivision map and we can compare the dates at a later time if necessary, but just want to make sure the record is complete. Risa, is 18 in?
Yes.
Have you ever seen, to your knowledge, Ms. Cargill, a subdivision map approved by the state engineer, either tentative or a final, prior to the receipt by the state engineer of a will serve letter or commitment from the water purveyor?
Mr. Sylvester, until you just showed me those letters from the Division of Water Resources that we just looked at, I'd not seen those letters before.
I agree. My question is a little broader. Have you ever seen in your capacity as COO and or general counsel, a subdivision map that or a tentative map or a final map that was approved by the state engineer without a receipt of a commitment or a will serve from a water purveyor?
I don't know that I have or I haven't.
Just go back to Cane Springs for a moment. The water that is owned or under option by Cane Springs, the point of diversion is in basin 210 or 206.
My recollection is that all of the Cane Springs permits have a point of diversion in basin 206 up the Cane Springs Road north of the Coyote Springs property.
And when you say north of, how far is it north of phase 1 of the Clark County Master Plan Committee?
A long ways. A long ways. I mean, I think that the southernmost point of diversion is somewhere between 2 and 5 miles north of the northernmost part of the Coyote Springs property line in Lincoln County.
And how long would that pipeline, if it's going to be in a pipeline, how long would that pipeline be to bring that water to phase one of the master plan community? If you know,
Objection, foundation. Sustained.
if you know, in your capacity, any capacity you enjoy, senior vice president, COO, general counsel, do you have any understanding of the distance, the physical distance that a pipeline would need to be built to bring it from the point of diversion to phase one of the Clark County portion of the master plan community?
I don't know, but the Cane Springs water was not anticipated to be used for day one.
So, but just to understand it, if you don't know the physical distance, but it wasn't intended to be used in phase one. Do I get that testimony correct?
I believe that's what I just said, maybe not precisely in those words, but yes.
Phase two began in February 26, 2026. Comport with your recollection?
It was February of 2026. If you represent to me, it was the 26th of February this year. I will accept that. I don't recall the exact date.
And I believe it was February of 2026. We'll leave it at that. Okay.
Okay.
Do you know what it means to designate a basin from the state engineer's perspective?
I don't understand but all the many specifics that probably means. I understand it on my own level.
Do you understand, and again, just generally, and if you don't have the foundation, tell me you don't have it, that when the basin is designated, the state engineer has additional management tools that it can employ to manage the water within the basin?
Yes, I think that's generally some of what that designation status allows the state engineer to do.
Okay. And do you know, after the commencement of phase two, that the lower White River flow system, including the basins in what's known as the super basin, was designated by the state engineer?
I know that there was a designation hearing on whatever that date was. Let's assume it was February 26, 2026. There was what the state engineer called to be a designation hearing that morning. And then the phase two hearing took place in the afternoon. I thought that the lower White River flow system had been designated in the 1309 order.
Okay. I'll represent to you and happy to show it to you if you haven't seen it, that on July 1st, 2026, the state engineer issued ruling 1343 that designated those basins as the statutory, as the statute provides and as you generally described it. Does that comport with your recollection? Only if you know.
I received and read on a very cursory level order 1343.
And when you read it, even on a cursory level, did you come to understand that those basins that had been the subject of 1309 had been designated by the state engineer?
I understood that they had been designated, but that's, as I say, very cursory level. I know you're going to be surprised by this, Mr. Sylvester. I was a little preoccupied at the
I don't
time.
know. What have you been doing? Withdraw the question. Though you know it's been designated, you don't necessarily understand the legal effect of that. Would that be a fair characterization of testimony?
I don't understand the full legal effect of it. I understand that it gives the state engineer various tools, Mr. Sylvester, but I couldn't sit here and delineate all of those tools for you.
Just for indulgence.
your designation.
Yeah.
You would mind?
Same.
Would you mind if I introduce the designation? Word?
May I approach, Madam Clerk, please?
Yes,
This is proposed State's Exhibit 4012. I approach the witness with a copy, Your Honor.
yes.
Thank you.
And we reference the 1343 designation order, and that you can see that you turn to the signature page, it was July 2026. Is that the document that you had reviewed cursorily?
Yes,
Offer the exhibit, Your Honor.
No objection, Your Honor.
It's admitted.
Council, just, I do have the e-exhibit that was given to me yesterday for
Okay.
this one. Is this different than? the
It is not.
e-exhibit?
I didn't know you had the exhibit.
Okay, I'll go this one back
Thank
to
you.
this. Okay.
You understand, Ms. Cargill, that the second phase or the phase that began February 26th was a continuation of the state engineer's attempt to discern a management plan of the groundwater within the basins?
Objection, foundation.
Sustained.
Do you understand as a COO, General Counsel, Senior Vice President, that the purpose of the second phase was to allow the state engineer to discern a groundwater management plan?
I understand that was one of the things that the state engineer has said. And as I mentioned, I think previously, Mr. Balaton at that meeting on February 26th identified 3 options, and those are the same 3 options that Mr. King had identified at the beginning of the 1303 hearings in July or September of 2000 and whatever year it was, 17 or 18, 2018.
Okay, and when you're talking about that time period, one of the things we looked at in many of the agendas was an attempt to get the stakeholders to come together and agree to a groundwater management plan. Do you recall generally that discussion you and I had?
I do. I don't remember if that was the exact words because I don't recall if the state engineer used those words, groundwater management plan. He could have, or it was just all you people in the room should get together and try to figure this out. And I just don't remember if he used those words in that order, groundwater management
Okay,
plan.
or maybe conjunctive management plan. Would that be more accurate from your recollection? And only if you recall.
I don't recall.
And do you understand, if you do, in your capacity, Senior Vice President, COO, General Counsel, that at the February 26, 2026 commencement of phase 2, that there was an encouragement by Mr. Balaton, state engineer, for the stakeholders to come together and reach an agreement on how to manage that water by and among themselves as one of the 3 options.
But Mr.
Objection, asked and answered previously.
I'm only talking about it from 2026 phase 2 process.
Overruled.
That was one of the 3 alternatives that Mr. Balaton described that matched Mr. King's descriptions 8 years previously.
Okay, fair to say though that since Mr. King referenced it in 2018 through at least February 2026, the stakeholders have been unable to achieve a consensual management plan by and among themselves.
The various people involved in all the litigation in those 8 years, correct?
And some that weren't in litigation. Aren't there other stakeholders that weren't involved in litigation? Only if you know.
I'm not sure about that, perhaps.
Okay. Rick, can I have 3931, please? And Ms. Cargill, we looked at this before, I believe, and these are let me lay some foundation. I think we talked earlier about the 2024 Supreme Court decision from regarding, or I should say entitled Sullivan.
Yes,
We went through some of that language, but ultimately what happened at the end of that, in part, the Supreme Court remanded it back to Judge Yeager for further findings. You understand that at least generally?
very generally, yes, very generally, I think that's kind of a way to say it.
I'm just trying to prompt your recollection. If you don't have one, that's fine. The issue before the Supreme Court, if you recall, in your capacity as general counsel and named in the published opinion as one of the caption counsels, that the Supreme Court was asked to determine whether the state engineer had the authority to combine the basins.
That was the question that the Supreme Court answered, that the Supreme Court said, yes, the state engineer could combine the basins, and that was what the Supreme Court answered.
Right. But in 2022, when Judge Yeager granted the petitions for judicial review, she granted it on the basis that the state engineer didn't have the authority, right? And that's what came to the appeal to the Supreme Court. Only if you understand it in your capacity as COO, general counsel, named counsel on the petition for judicial review challenging 1309.
My objection is that Judge Yeager's findings of facts and conclusions of the law in 2022 speak for themselves.
What's the objection? I couldn't hear
That
it.
the judge's ruling in 2022 speaks for itself, Your Honor.
Just asking if she understands that to be the scope of the ruling.
Overruled.
Judge Yeager's ruling had lots of findings of fact in it, and she didn't decide any, I don't remember, Mr. Sylvester, if I just don't.
That's okay.
She didn't decide anything other than he didn't have the authority, and then that's the question that went to the Supreme Court. And so without pulling it up and walking through it, I don't remember everything that she had to say through all of it.
And you're exactly right. That's what her ruling was limited to, the fact that he didn't have the authority. And again, I'm not quarreling with you or suggesting the order said something different. I accept your understanding only. Supreme Court then sent it back to her, Judge Yeager, say, now go figure out the other issues that were presented during that PJR. Just generally, do you understand that?
Objection, the Sullivan decision speaks for itself.
Just asking for her understanding.
It speaks for itself.
You know what the scope of the remand was to Judge Yeager?
I thought it was very narrow, but again, although you continue to say that I'm caption counsel and whatever that means, and that my name is on these things, I don't know, Mr. Sylvester. I wasn't a part of, I'm not a litigator. I don't know specifically. To me, the Supreme Court told Judge Yeager, we disagree. Mr. Sullivan had the authority to combine basins, and that's what was remanded to Judge Yeager. Was there best available science, or whatever the correct terminology that was used, was there best available science for the state engineer to issue the 1309?
Okay. Now I want you
And I'm probably misstating that. But at that, I'm probably misstating it.
if I could have you turn to 004, we'll just spend a little bit of time going through the findings that were made by Judge Yeager on remand, specifically in part as it relates to CSI, okay? At 004, it talks about interim order 1303. And if you just read the first full sentence into the record.
On January 11, 2019, based on concerns about water availability for existing water rights and the Moapa Dace, the state engineer issued interim order 1303 to start a two-phased administrative process in the multi-basin area known as the Lower White River Flow System, footnote 19.
Okay, I'll read the next sentence into the record for you. He delineated the Lower White River Flow System as a joint administrative unit and invited stakeholders to participate in an administrative hearing to address the factual questions of what the boundary of the Lower White River Flow System should be and what amount of groundwater could be sustainably pumped in the Lower White River Flow System. At page 0015. Page 15.
5001.
And as it relates to CSI, or Cane Springs, I should say, it says based on the evidence of the hydrological connectivity, the state engineer found that the Lower White River Flow System consists of Cane Springs Valley, Coyote Springs Valley, Muddy River Springs area, California Wash, Hidden Valley, Garnett, and the northwest portion of Black Mountain areas. It says the state engineer's rationale for combining these subbasins was that the basins share a close hydrologic connection and the same source of water. Although contradictory evidence appeared in the record, the state engineer found that such evidence was unreliable and not based on the best available science. The state engineer therefore discounted or rejected that evidence. The court finds, based on the standard of review, substantial evidence supports his record. And we won't read much of the balance of it, but just a couple of different points at 0016. You can see the reference to the 1964 USGS survey, indicating that the Coyote Springs, Cane Springs, and Muddy River Springs area share a perennial yield and are part of a larger groundwater system comprised of neighboring and upgradient valleys that supplies most of the flow of the Muddy River. As I recall, your testimony on cross-examination is that when you did your deep dive, you looked at those USGS surveys and the studies and literature with respect to the potential hydroconnectivity of those basins. Did I get your testimony accurate?
I recall that we've spoken about that and that I did say that, and I did review various reports and studies that I could find or get my hands on. And I reviewed them. I don't know that I reviewed them for hydrological or hydrogeological purposes. I read them to see generally what they would say.
Okay. And at page 0017, just the last sentence of the last paragraph beginning at line 11, just read into the record, given this evidence, please.
Given this evidence, the state engineer's conclusion that the single source of water should be managed jointly to protect existing Muddy River water rights and public interest was reasonable, footnote 86.
Okay. And at 0021, please, this references information provided by CSI.
Where do you see that?
At 0022, Brendan,
What line, Mr.
is as to
Sylvester?
the fifth criteria, CSI, Lincoln County.
Oh, at the very top.
And Bidler relied on a 2019 field investigation conducted by Zahn International to argue that a geologic structure in southern Cane Springs operates as a complete or partial barrier, and the sentences finishes. At the bottom, at line 21, states the court notes the state engineer found the methodology by which Zahn report located the purported fault to be flawed. Is Zahn's report one of the experts that was submitted by CSI during the 1303 hearings, to your recollection?
Yes, Coyote Springs and Vidler and Lincoln County Water District retained Zong International, Mr. Norman Carlson, who's a scientist. I don't remember his exact background, who went out and performed a variety of scientific and geophysical examinations in the basins nearby. I think Basin 206, 210, and 219, if I remember right. And that was submitted during the 1303 hearings and then developed further after that as well.
Brennan, 20025, please. Ms. Cargill, one of the things that you said as it relates to those two rulings, well, more than two, but 6254 and 6255, was that the purpose of the pump test was to essentially determine whether applications could be granted, further applications, right?
The 1169 pump test?
Yes.
Yes, it was for the applications that were pending at that time.
And then what you said following that is that you were, my words, pleased or satisfied from your review of 624, 54 and 55, that the rulings protected the existing rights, protect CSI's rights in Basin 210. Did I get that testimony correct?
Yes.
Objection, incomplete summary of many questions and answers of that testimony.
Yes, ruling 6254 and 6255 did, among other things, all the various, I know I've testified about this before, Mr. Sylvester. So taking together everything else I've said collectively, 6254 and 6255 protected Coyote Springs's as senior water rights holders interests that were existing rights, existing permitted rights. And it also set forth, in any event, yes.
Okay, that's what I thought your testimony was. At 0025, if you just read into the record the paragraph that's again at 16.
CSI argues the state engineer should not have relied on data from the aquifer test to determine hydrologic connectivity because the test was intended to determine if water was available for additional appropriation, not to provide a comprehensive view of the LWRFS footnote 125. This court finds, regardless of the decision of the state engineer was considering when he ordered the aquifer test, that the state engineer considered the water level data and hydrographs from that test to be valuable in understanding the connectivity of subbasins in the LWRFS. The court finds no basis as to why the state engineer should be required to ignore this relevant and important evidence. The basis under which the evidence was collected has no bearing on the relevance and importance of what that evidence shows. The court concludes that the state engineer's reliance on data from the aquifer test is reasonable in light of the state engineer's expertise and the evidence before him.
Okay, just looks like 3 more spots and then we'll be done. At 0031, please. And begin reading at line 4 through line 13, please.
The state engineer also explicitly acknowledged that adjustments may be made in the future as, quote, there remains some uncertainty as to the extent that distance and location relative to other capturable sources of discharge either delay, attenuate, or reduce capture from the springs, footnote 165. As more data is collected in the future and becomes available, the state engineer will be better equipped to determine how pumping in locations within the LWRFS that are distal from the Warm Springs area affect the flows. The court finds it is not arbitrary or capricious for the state engineer to make decisions based on the current body of evidence, even if more complete and detailed information about how location and distance from the Warm Springs impact the flow is not yet available. The state engineer is required to, quote, consider the best available science in rendering decisions concerning the available surface and underground sources of water, end quote, footnote 166. The operative word being, quote, available, end quote.
Simply because further testing has not been done to precisely define how distance and location correlates to reduction in flow does not preclude the state engineer from making decisions based on the evidence that he currently possesses. Ms. Cargill, if you know, did you understand, at least from 1309, and then again reading Judge Yeager's findings of fact and conclusions, that there may well be an opportunity for CSI and other stakeholders to demonstrate scientifically that water can be diverted from different portions of, for instance, Basin 210, that may not impact or affect the down gradient rights, only if you know.
Objection, foundation.
That's only if she knew.
Overruled.
Mr. Sylvester, at this point, it's 2025 and Coyote Springs doesn't believe we're going to be allowed to go forward. We've had counsel on this case over 6 years at the time of this decision, and we were being advised by counsel, and I don't think there's anything I can add.
Let me ask you this. Without asking you to disclose the attorney-client privilege, are you going to try? Are you going to try to demonstrate to your knowledge that water can be pumped in the phase 2 process without conflicting with decree rights?
I can't discuss that without disclosing advice of counsel.
Have you hired any experts or retained any experts or consultants, again, without disclosing the privilege, to set forth that evidence in phase 2 that some water can be pumped, whether it's distally located from the down gradient rights or in a manner that won't impact the down gradient rights?
Our counsel has had consultants retained for some time
For that purpose?
Objection, to the extent that would require you to disclose litigation strategy or communications, I would caution you not to do that.
Sustained.
Well, I think it was a caution, Your Honor. If she testifies that she can't, then
Let's make it an objection then, Your Honor.
let me try to work around the objection. Without referencing attorney-client privilege communications, do you understand whether or not CSI has retained experts to determine whether they can divert water from Basin 210, either distally or otherwise, without conflict with the downgrading decree senior rights in the Muddy River?
I don't think I can speak to that because of privilege issues, Mr. Sylvester.
Without disclosing attorney-client privileges, do you intend to participate in the ongoing industry proceeding?
That will be subject to discussions with counsel.
Okay. Last paragraph, last time you have to read to 0033, please, and pick up from line 4 and through the end of that paragraph.
As the Supreme Court recognized in Sullivan, the state engineer's findings in Order 1309 were, quote, purely factual, end quote, footnote 174. Therefore, any concerns about legal conflicts between junior groundwater rights and senior surface water rights will be addressed by the state engineer at a later date when he develops a management scheme for the lower White River flow system. The state engineer's factual determination that the sustainable pumping maximum in the LWRFS is 8,000 acre-feet or less was not a conflicts analysis and is independently supported by substantial evidence in the record.
Cargill, that's all I have. I appreciate your participation in the 3 or 4 days we've been together. And the outside chance that Mr. Hutchison may want to ask you one or more questions, I would turn it over to him.
Thank you. Your Honor, should I proceed?
Yes,
Thank you. Your Honor, may I may I take care of a housekeeping matter concerning exhibits? Council and I have consulted, and if I could make a record of what we would be submitting as stipulated exhibits, Your Honor. This is going to be the following: Exhibit 433.
433.
Yes, Exhibit 434. Exhibit 435. Exhibit 437. Exhibit 438. Exhibit 439. Exhibit 440. Exhibit 441. Exhibit 442. Exhibit 443. Exhibit 444. 445. Exhibit 446. 454. 455.
I'm sorry, Mr. You said after 446, what was it?
446 and then 454.
45.
Yes, ma'am. And then 455. 456. 457. 458. 459. 460. 467. 470. 519. 520. 521. 524. 525. 530. 531. 532. 533. 534. 535. 536. 537. 538. 539. 540. And 541.
So stipulated on.
Thank you, counsel.
right, they're admitted by stipulation.
Thanks so much. Let's, Ms. Cargill, we haven't had a chance to speak for a while, with me at the podium here. But let's start off with a continuation of a few exhibits I'd like to just have you consider and see if you recognize those, and then we'll see if we can just admit those by way of foundation and initial discussion. If you could please bring up, Hunter, exhibit 3700.
Is that a proposed exhibit?
This is, yes, this is I'm sorry, Your Honor, this is a proposed exhibit 3700. And Ms. Cargill, do you recognize this document?
Yes, I do.
What is it?
This is a letter dated June 13, 2019. I believe it's signed by me. It's addressed to Mr. Tim Wilson as acting state engineer. And it's regarding a submittal pursuant to interim order 1303. And the letter states that I've enclosed 2 documents, a technical report from Stetson Engineers and a Mylar set of the large lot Coyote Springs Village A map.
Thank you. Offer exhibit 3700, Your Honor.
Objection to hearsay as it relates to the attached report, Your Honor. I mean, to the extent that that document reflects the attachments. Counsel, could you pan down, please?
Overruled, it's admitted.
Thank you, Your Honor.
Your Honor, yeah, just so the record is clear, I want to see if I can the documents that were attached. Those appear to be expert reports that were submitted in connection with the, with the request to demonstrate the scientific availability of water. And I think that that would be hearsay. Certainly for the effect on the listener, I don't object, but the idea that substantively those reports are coming into evidence without the foundation and the author of those reports, I think is inappropriate.
You know, she's testified to these reports before previously. She is, and I can ask her, I'm happy to, if this letter as well as the expert reports is something that would have been maintained as a business record in the ordinary course of business operations at Coyote Springs.
Yes.
Again, it's a scientific analysis. If the reports are in fact attached, she can certainly, again, from an effect on the listener standpoint, but scientifically, she doesn't have the foundation to identify or discuss those scientific reports. The letter itself is fine. It's the attachments I'm concerned about.
Well, it shows what was sent, and for that purpose, I admit it, not the truth of the matter asserted, but what was sent.
Very good. Thank you, Your Honor.
All right, thank you, Your Honor. Let's go to exhibit 17, please.
Which one is it?
Yeah, proposed exhibit 17, Your Honor. Ms. Cargill, I'm sure we've talked a lot about these. I'll just ask, I proffer exhibit 17.
No objection, Your Honor.
Thank you.
It is?
Let's go to exhibit 41, please. This is just another application for extension of time, which I think was missed. Just offer exhibit 41. Your Honor.
No objection.
Thank you. Exhibit 3848, please. Proposed exhibit 3848. You'd had extensive discussion about this on cross-examination. Ms. Cargill, I'd offer up exhibit 3848.
Objection to hearsay, Your Honor.
I'm sorry, what?
Hearsay and foundation.
The foundation for it.
Yeah, Ms. Cargill, do you recognize this document?
Yes, I do.
What is it?
This is a document that I worked with other people, but in particular Teresa Gardner, and we created based on it summarizes all the other various costs and backup that relate to Coyote Springs and all of the financial records of Coyote Springs from as far back as Ms. Gardner could find through to the last year that it stated that it covers 2022.
And in working with Ms. Gardner, did you discuss with her and confirm with her that the document here in front of us reflects figures that are backed up and supported by the Coyote Springs business records?
Yes,
And is this a fair and accurate summary of those business records as depicted on this table and in this document?
yes, it is.
Offer exhibit 3848, Your Honor.
Your Honor, this document was prepared in connection with the litigation in response to a discovery request with respect to the total amount incurred to date and with respect to the improvements, so it cannot be a business record.
Judge, of course it can be. This is just a summary of business records that admitted to all the time under the
Admitted.
evidence.
Okay, let's adjourn now and reconvene tomorrow at 1:30.
Thank you.
Now in the midst of redirect. Okay,
Thank you.
You said 1:30 tomorrow, Your Honor?
yeah, tomorrow. I got motions all morning.
No, I haven't. I think we started 2 if you like, Judge.
All right.
Judge, honest says we 15 just for- honest said-
Well, there we go. We're back tomorrow at 1:30 p.m. So I get the first half of the day off. Yay!
Guys wanna
But
come back
we'll
and-
probably be inside of, you can hear in the background there.
I'm
Would
sorry.
you prefer 1:30 or 1:15? I probably got a lengthy motions calendar tomorrow.
All right, what 1:30?
I have to my staff.
1:30 is fine with us. Yes.
1:30.
Thank you so much.
Good thing we were listening in. All right, so we will wrap up the day as far as the Coyote Springs trial is concerned.
No, I'll
There's-
see you Tuesday.
They're still being loud.
I was all ready to wrap up. That's a nice little book. Have a good day.
See when they cut the feed here.
You know what I have, I was doing, how I.
I told her
We just off screen.
Anyway, it's like.
But I do have it written down.
This is always a meeting starter.
I printed out, it's like I need to really go start.
I love these behind the scene moments. There you go. Like, y'all better cut the camera before you say something you don't want to say. Woo! Because I will report on it. Here we go. So we're going to wrap up. We'll be back tomorrow around 1 p.m. That way we can get you up, ready, on point, get the stream going. Right now, I'm going to wrap up this stream with you, and then I'll get my notes out for my day wrap. Day 9 in the books tomorrow, day 10 starting at 1:30 p.m., and that will be Thursday, August 13th. I have my son's 12th birthday. We've been celebrating all week, but I want to go spend time with him, and that's what I'm going to go do right now. But we'll wrap up these notes, get you guys an update out there. Thank you so much for tuning in today. And I appreciate you once again. Carson, Churchill, Clark, Douglas, Elko, Esmeralda, Eureka, Humboldt, Lander, Lincoln, Lyon, Mineral, Nye, Pershing, Story, Washoe, and White Pine counties, all 17, not just 2 in a sports book. We love you, Clark and Washoe. Not as much as you love yourselves, but we do love you. So we'll see you tomorrow. Thank you. And as always, remember, we're not just Vegas, okay?
We're not just
We're not.
Vegas. You're not.
Read the whole map.
Read the whole map. Read it. Lights don't run the state. No, they don't. That's a small cap. Small cap. We're not just Vegas. Look around. Past the neon haze. Past it. 17 counties. All of them. Different lives, same place. Same soil. Same soil. They think Nevada starting in on the strip. That's like judging a book off the cover it get. Vegas loud, yeah, but that's just a slice. Plenty state left once you drive past the lights. There's towns where a handshake still means something. Where folks know the land and the seasons are blunting. Where work don't trend and patience is learned. Where votes still matter cause people return. We don't all gamble, we don't all party. Some folks wake early, boots, dusty coffee. Some places quiet, some places spread. Some rows long conversations with your head. The state breathe wide, not stacked in a frame. Don't shrink us down to a postcard name. We're not just Vegas, no way. No way. That service talk, surface. Surface. Real Nevada, out here. Out here. Outside the wall, outside. Outside. This land where the sky feel heavier blue. Where the silence louder than the news. Places built slow, no rush to impress. Where people still show up, not just express. Some counties keep food on shelves you don't see. Some keep water managed responsibly. Some keep the lights on, roads still paved. Some keep the history from getting erased. Not every voice come with billboards and sound. Some carry weight just by sticking around. We don't move fast, cause we plan ahead. We don't burn bridges, just to feel said. Nevada ain't one tempo, one look, one lane. It's contrast stitched into the same terrain. We're not just Vegas, past the glare, past it, past it. The state move quiet, steady, everywhere, everywhere, all around, all around. If you move here, welcome, just learn the pace. Respect the ground, don't rush the place. We don't copy cities that couldn't hold. We're not just Vegas, yeah, no, yeah, no. Read the whole map, read it, read it. Lights don't run the state, no they don't, no they don't. That's a small cap, small cap. No, we're not just Vegas. Look around, look around. The neon haze, past it, past 17 counties, all of them. Different lives, same place, same soil, same soil, same soil. They think Nevada starting in on the strip. That's like judging a book off the cover it get. Vegas loud, yeah, but that's just a slice. Plenty state left once you drive past the lights. There's towns where a handshake still means something. Where folks know the land and the seasons are blunting. Where work don't trend and patience is learned. Where votes still matter cause people return. We don't all gamble, we don't all party. Some folks wake early, boost dusty coffee. Some places quiet, some places spread. Some rows long conversations with your head. The state breathe wide, not stacked in a frame. Don't shrink us down to a postcard name. We're not just Vegas, no way, no way. That surface talk, surface, surface. Real Nevada, out here, out here. Outside the walk, outside, outside. This land where the sky feel heavier blue. Where the silence louder than the news. Places built slow, no rush to impress. Where people still show up, not just express. Some counties keep food on shelves you don't see. Some keep water managed responsibly. Some keep the lights on, roads still paved. Some keep the history from getting erased. Not every voice come with billboards and sound. Some carry weight just by sticking around.